Hi, we are back. So sorry for the technicalities. Let's move on, please. Now, section 101 of application of proceeds of sale of charged land. The purchase money received by a chargee who has exercised the power of sale shall be applied in the following order of priority. Number one, it will first be used to pay any rates, rents, taxes, charges, or other sums owing and required to be paid on the charged land. Second, it will be used in discharge of any prior charge or other encumbrance subject to which the sale was made. Third, in payment of all costs and reasonable expenses, okay? Properly incurred and is incidental to the sale or any attempted sale. Fourth, it will be used in discharge of the sum advanced under the charge or so much of it as remains outstanding, interest, cost, and all other money due under the charge. Okay, so it will also be used to discharge the sum advanced under the charge. Okay, or any remainders, any arrears that are were remaining unpaid, okay, including interest and costs and other outstanding charges. Okay, then lastly, it will be used in payment of any subsequent charges in order of their priority. We say that sometimes someone can be like the flag bearer of all borrowers in the world and borrow against a property multiple times, so we have also other co-charges who are waiting to be paid. They will also be paid in order of priority. Okay, now moving on, section 102, right of charger to discharge charge on payment of any sum due any time before sale. So the charger has a right to discharge the charge, okay, at any time. I said before sale, even if the sale is tomorrow, if they are able to gather enough funds by today, end of day, and pay you, so tomorrow you are not going to exercise your power of sale, okay, the charge would have been discharged. Now, section 102, subsection 1, at any time before the charged land is sold or withdrawn from sale, the charger or any other person entitled to discharge the charge may discharge the charge in whole or in part by paying to the chargee all money secured by the charge at the time of payment. So they can pay money, okay, all the money secured by the charge before the sale happens. Subsection 2, if payment is made under subsection 1, the chargee shall deliver to the charger the following things, okay, a discharge of the charge in the prescribed form over the whole or part of the charged land to which the payment relates. So once the charger makes the payment, the chargee on the flip side will do the following things. They will give the conveyance, it's called a discharge, okay. It will show that that instrument that will show that the charge has been fulfilled or uh, has been, what do you call it, has been, whatever the language, but it's no longer there, okay. A discharge of the charge, it will take a particular form. We are going to learn about these forms in the Land Registration Act. So over the whole or part of the charge land to which the payment, okay, so the chargee will deliver the discharge and also all instruments and documents of title that he was holding, okay, as lien, he will give them back. Okay, moving on, section 103, application for relief by charger. Now, an application for relief against the exercise by the chargee of any of the remedies referred to in section 85 3A and B may be made by the charger. Okay, so the charger has some reliefs, okay. The law gives them relief. So they will apply against the power of sale if two or more persons are joint chargers by one or more of them on their behalf. So in case of a single charger who is a single proprietor of land, they will apply to the court by themselves. If there are co-owners in the case of co-tenancy, two or more persons, one of them can represent the others by applying to the court. If in case of a couple, a spouse of the charger can go and apply to the court on behalf of both of them. In case of a lease, the leasee of the charger can go and apply to the court. Okay. In case of the trustee In case of a trust, the trustee in bankruptcy of the charger, okay, can go and apply, you understand, for relief to stop the chargee from selling the land. So we see that the law allows the charger, in case of power of sale, to go and apply to the court to stop it from happening. Now, subsection 2, if an application made in accordance with subsection 1b is not made by all the joint chargers, then, unless the court orders otherwise, it must be served on all the joint chargers, okay? If we say that in case of co-tenancy and we have like several chargers, okay, who have that charge on their property, one of them can apply to the court, and in case only one applies, then the application will be served on all of them, okay, so that they are informed. So, moving on, subsection 3, an application for relief may be made at any time after the service of a notice under section 91, section 91 2, and section 94 1, section 95 1, or during the exercise of any of the remedies contemplated in those sections. Application for relief may be made at any time, okay, after the service of a notice. Remember, we said there are notices where first, in exercising the remedies under this act, the chargee will first need to give a notice in the prescribed form stating the nature and extent of the default, the consequences, the timeline to remedy, what to do or refrain from doing, the money to pay or something. So then he waits for like 2 months. If the charger does not comply within that period, then they serve a notice to either lease the land or to sell the land, okay, to the charger. So what this section is saying, that an application for relief can only be made, okay, after the service of a notice to the charger. After the service of the notice to the charger, yes, once the charger receives that notice of power to sell, notice of sale, notice of lease, then they are going to apply to the court, okay. um, Now, moving on, subsection 4, an application for relief is not to be taken as an admission by the charger or any other person applying for relief that there has been a breach of a covenant of the charge by the charger, okay? So when the charger goes ahead to apply to the court to stop the chargee either from leasing the land or from selling the land, what they are going to do is, it that simple action of applying to the court does not prove that they are guilty, okay, of the default that has been claimed by the chargee, okay. It doesn't mean they breached the covenant. It's not an admission of guilt. That's all you need to know. Number 2, by reason of such a breach, the chargee has the right to exercise the remedy in respect of which the application for relief has been made. So, by reason of such a breach, the chargee has the right to exercise the remedy in respect of which the application, okay. So it doesn't also mean that the chargee now has the right to go ahead and sell, okay. It also doesn't mean that all notices that were required to be served have been properly served in the time specified by this act that we discussed yesterday and in the manner, okay, following the guidelines, all right. So another assumption, it doesn't mean that the period for remedying the breach specified in the notice served under Section 90 was reasonable or had expired. It also doesn't mean that the chargee had given them ample time to remedy, maybe to pay up or to stop doing something or to start doing something, okay, under that notice. It doesn't mean that the period is up and they didn't comply by applying to the court. So, and the court may grant relief. The court may grant relief uh, without determining all or any of the matters described that we have discussed. Okay, so the court can go ahead and grant relief to the charger who is applying for relief against the power to sell or dispose of the land by the chargee without even looking whether the time is up, whether there is non-compliance or default on the part of the charger. Okay, so I'm really happy to see this. I'm, I'm really happy because all this time we have just been discussing how the charger should keep the property in good repairs, should not do anything stupid on the charge land, should do this and do this, all to protect the interest of the bank or the chargee. But now, at least finally, we see that the law allows for relief, so the charger can apply to the court, and even while applying, it's not an admission of guilt on their part, and the court can go ahead and grant the relief even without looking at all these things we have said, such as compliance notice was done properly or this breach or what. Okay, so moving on, section 104, power of the court in respect of remedies and reliefs. So let's see, does the court have discretion, total absolute discretion, to decide whether it wants to grant a remedy or not, uh, or is it limited, in what scenarios, what are the exceptions? Let's see. So section 104 subsection 1, in considering whether to grant relief as applied for, okay, a court will do the following things. Okay, the court shall have regard to whether the remedy which the chargee proposes to exercise is reasonably necessary to prevent any further reduction in the value of the charged land. So first the court will see that is what the chargee demanding from the charger in the notice, is it reasonable, is it necessary, okay, to in order to preserve the value of that land. This, I think, goes in the case where the chargee demands that the charger does something on that land or refrains from doing something on that land. Okay, maybe to preserve the value and their interest as a bank. So the court will look at this. Is it absolutely necessary for this? Is it reasonably necessary for this act to be done or to be omitted? Okay. Um, mhm. So this will be in the case like agricultural land. We say that an agricultural land is a vulnerable piece of land that you have to handle with care like a baby. Like it's subject to environmental degradation, it's subject to erosion and all these things. Commercial premises, okay, like offices, the remedy proposed is to appoint a receiver or to take possession of or lease the land. So where the chargee is seeking to appoint a receiver or to take possession of or release the land or of the land, the court will look at the necessity principle or test. Just know that the court will look at the necessity. Is it necessary? Moving on, number two, the court will also, where the charge land consists of or includes a dwelling house, like this house, your home, my home, and the remedy proposed is to appoint a receiver or take possession or release the dwelling house or part of it. It will have regard to the effects that the appointment of a receiver or the taking of possession or releasing the whole or part of the dwelling house would have on the occupation of the dwelling house by the charger and dependents. All right, and if the effect would be to impose undue disturbance on those owners, whether it is satisfied that. So we said that in the case of a dwelling house, we said yesterday that the chargee has to provide alternative accommodation. Okay, kama pengine ni one bed sitter and they want to lease, you provide an alternative accommodation for them, for the charger and the family. But if it's a house that like has many rooms and multiple spaces and common areas, so maybe the chargee is required by law to do what? To lease part of it and leaves another part for the occupation of the charger and his family. You understand? So the court will also look at this. It will look at the dwelling house and see if the chargee goes ahead to lease part of it or whole of it. How is that inconveniencing the charger and the family of the charger? Okay. And if it is satisfied that, let's look at these things. Number one, the chargee has made all reasonable efforts, including the use of other available remedies, to induce the charger to comply with the obligations under the charge, and the charger has persistently been in default of the obligations. If the sale is of land held for and if the sale is of land held for a customary land, the chargee has had regard to the age, the means, and the circumstances, including the health and number of dependents of the charger, and in particular whether the charger will be rendered landless or homeless. The charger will have any alternative means of providing for the charger and dependents. Okay, it is necessary to sell the charged land in order to enable the chargee to recover the money owing under the charge. In all the circumstances, it is reasonable to approve, or as the case may be, to make the order to sell the charged land. So the court will look at all of these things I've mentioned when it comes to a dwelling house. Okay, if it's a dwelling house, it will look at if the chargee has used other remedies available apart from leasing or selling this dwelling house. It will look at um, it will look whether the charger is guilty of continuous default, because also the law does not help someone who keeps on, I think it's a maxim under equity, who keeps on just committing that problem over and over again, like you default 100 times. So also the law is not like unjust to the chargee as well. Even while it seeks to protect the charger, it still will look at their due diligence. Have they at least tried to pay up? Have they at least tried, to correct the mistake? So that will be looked at. Also, if the sale is of land held for customary land, the chargee, it will look whether the chargee has been merciful or considerate, as long as the land is customary and the dependents age, the means of their living, the circumstances, the health, and number of the dependents. So the court will also look whether the chargee was considerate as to the circumstances of the family in that customary land. The charger, it will also look whether the charger will be rendered landless or homeless if the chargee were to move ahead with the plan to sell or lease. It will also look at whether the charger will have any alternative means of providing for himself and his dependents. Okay, in case, for example, it is a customary land, people, the whole family lives there, they maybe keep animals to for livelihood as source of income, maybe they keep a farm of chickens and stuff on that land. So it is necessary that for the court to look at whether these people, if the chargee exercises the power to sell or lease that particular land, whether they will be rendered homeless, whether they will have no means of livelihood because everything is on that farm, if in case of a farm or on that piece of land. Okay, now all these things will be put in consideration. Okay, the court will also look at whether it is necessary to sell the land in order to enable the chargee to recover the money. So it will also look at necessity. I told you the necessity principle will apply here. Whether in all the circumstances it is reasonable to approve to make the order to sell the charged land. So it will look at whether it can give the final approval after considering everything I have told you. Okay, I have said. Now subsection 2, a court may refuse to authorize an order or any grant under or may grant any relief against the operation of a remedy that the circumstances of the case require, and without limiting the generality of those powers may do the following things. Okay, so they may refuse to authorize an order or may grant it. May grant, okay, against the operation of a remedy, may grant relief. and will do the following things in doing so. First, will cancel, vary, suspend, or postpone the order for any period which the court thinks fit. So it will cancel the order, okay, or suspend it or postpone to another period. Two, it will extend the period of time for compliance by the charger with a notice. So in case the notice said, uh, no, the period of compliance is statutorily provided under the act, which is within 2 months, the charger needs to apply, to comply, okay. But also we say there's conflict of laws, because under the same section we had the notice under a lease would require within 2 months, not less than 2 months, under a sale not less than 3 months. But I don't know why they confuse themselves. So here the court will extend that period. It has discretion to extend the period of time for compliance by the charger. Now, so number three, it will substitute a different remedy for the one applied for. For example, if the chargee is applying for power of sale to sell the land or to take possession, maybe the court will alter or change it to the power to maybe lease. They will say you can lease part of this land for this, and from this point to that point, then you leave some for them to stay and continue their farming or something, you see. So it will intervene in that respect. It can substitute a remedy with a different one. So then it can authorize or approve the remedy applied for or proposed by the chargee. Okay. So it can also go ahead and support the chargee's remedy and authorize it. If it's about to sell, allows him to sell. If it's about to lease, allows him to lease. If it's about to take possession, allows him to take possession. Okay. And we say taking possession is not just physical, you take your ass to the place. No, you can also just start taking rent. Okay. If that property is being leased by the charger, you start you start receiving the rent from that day on. So from the day you start receiving the rent, you are taking possession of that property. So moving on, uh, mm, so the so the charger or other person applying for relief was made fully aware of the action required to be taken under or in connection with the remedy. What is this? Yeah, so I'm talking about where the court authorizes or approves the remedy applied for by the chargee. The court will have to be satisfied of the following two things. Number one, the charger or other person applying for relief was made fully aware of the action required to be taken in connection with the remedy. So, where the charger was made fully aware and was not surprised or by the consequence of their action, by how to remedy their default, they were made fully aware and they still did not do anything, and where no injustice will be done by authorizing. So the principles of natural justice apply here, where there will be no just injustice done if the court authorizes the sale of land by the chargee, then the court will go ahead and authorize. All right. Now that authority can be absolute, or it can also be limited by conditions, such as compensation, maybe as the court thinks fit, expenses. So subsection 3, if under the terms of a charge, the charger is entitled or is to be permitted to pay the principal sum secured by the charge by installments or otherwise, okay, to defer payment of it in whole or in part, but provision is also made in the charge instrument or any collateral agreement for earlier payment of the whole sum in the event of any default by the charger or of a demand by the chargee or otherwise, than for purposes of this section the court may treat as due under the charge in respect of the principal sum secured and of interest on it only the amount that the charger would have expected to be required to pay if there had been no such provision for earlier payment. I don't understand. It's very long. So is entitled to be permitted to pay the principal sum secured by the charge by installment, defer payment of it. Instrument of any collateral agreement for earlier payment in the event of any default by the charger or of a demand by the charger. Purposes of this section, the court may treat as due under the charge in respect of the secured and of interest on it only the amounts that the charger would have expected to be required to pay. Okay, I don't know. Is this against the charger or for charger? I think it's against the charger. I don't know, but let's just write it down. Section. This is under the powers of the court. So section 104 subsection 3 needs further more time, but so subsection 4, a court must refuse to authorize or approve a remedy if it appears to the court that 1, 2, 3. So a court can refuse to authorize a remedy by the chargee, okay, if it appears that the default in issue has been remedied. If the court finds that in fact the charger remedied the default, if it's a breach of condition, they remedied it by refraining from doing something or by doing something. If it's payment, they made the necessary payment, okay. If the court can see that the threat to the security has been removed, okay, so if it can see that whatever it is the chargee was worried about will reduce the value of that land, okay, and the value of the money payable, Jesus, can't believe this. Now, so where the chargee, where the threat has been removed that the chargee was concerned about, that will be the court will refuse to give authority or they go ahead for the chargee to exercise the power. Where the chargee has taken the steps that the chargee uh, was required to take by the notice. So where the charger takes the steps that the notice, the demands, he fulfills them, okay? He fulfills them. There's no need for the chargee to exercise the power of sale. So it will be refused. The order to exercise the power will be refused, okay? And the chargee has taken or attempted to take some action against the charger in contravention of section 94. So section 94 was talking about, let's just look back, it won't kill us because this is important. Section 94, 94, come on, come on. So section 94 we said was on remedies of a chargee. The remedies we said were only exercisable after you have given a notice of demand. That notice will say the nature of default. It will say the payment of the amount of money at the specified time. It will say what the charger needs to do or refrain from doing. It will say the consequences if they don't do that. It will also say the right to apply for relief to the court by the charger. So this is subsection 4 that is being referred to here. It says this: if the charge is a charge of land held for customary land or community land, shall be valid only if the charge is done with agreement of members of the family or community. The chargee may appoint a receiver or apply to court for an order. So now I understand. Where I told you that when it comes to customary land or community land held under a charge, okay? The bank has a tough time. You don't just you go ahead like in a private land and write notice and then take possession, or send a notice to sell or do all those things. You have to go through the court channel we discussed yesterday. You must apply to the court, because now I think the rationale is simple. It's not just one person who will be affected, it's a whole community in that community land. It's a whole family or clan in that customary land. So there are stricter rules to protect, the interest of those people. All right. So the chargee applies to the court if he wants to exercise any of those remedies, okay, and will appoint a receiver of the income of the charged land. So all these things, if they are not followed by the chargee and the court sees that it's not followed when it comes to community or customary land, then it will refuse the application of the order to sell or exercise any of the remedies. I think up to there we are clear. Mhm. So we move on to power of the court to reopen certain charges and revise terms. So section 105, the court may reopen a charge of whatever amount secured on a matrimonial home in the interest of doing justice between the parties. Okay, I don't know what that means, but we will check it out. Section 105, because it stops there. Power of the court to reopen certain charges and revise terms on matrimonial property. Now, we move on to section 106, exercise of power to reopen certain charges. All right, just a minute. Just a minute, please. I want to send an important text. Okay, so let's move on. Thank you. Exercise of power, we say, to reopen certain charges. Under section 106 subsection 1, the court may exercise the powers conferred on it by this act either to do the following things. In the following situation, A, on an application made to it for that purpose by either the charger or the chargee, to enforce the charge or to commence an action under section 90. An action under section 90, we said, was when the chargee wants to exercise the remedies by issuing a notice. Okay, they are going to. Okay, so in exercise of the power to reopen, the court may exercise these powers on application by either the charger or chargee to enforce the charge. So where the chargee, for example, goes to apply to the court to enforce the charge, okay, where maybe there's default on the part of the charger, where the where the what under section 90 of Section 90, we just read it. We talked about community land, sending notices to the charger. The notice should take this form. So all that under Section 90, if they want to commence an action of remedies on any of those things, the chargee will apply to the court. Now moving on, under B, on an application by the charger for relief against the exercise by the chargee of any remedy in connection with a default by the charger under a charge. When the charger applies to the court for relief, okay, the court will exercise this power to reopen certain charges. I still don't get what reopening certain charges means, but let's read, maybe we'll understand. So, C, on an application by the registrar in respect of two things: charges provided by one or more specific charges, where there is prima facie evidence of a pattern of unfair dealing and practices by that chargee or those charges. Okay, so where the charges have been involved in unfair dealings or fraud practices, so the registrar will apply to the court. Okay, in this scenario, and where the chargee, being a corporate body that appears to exercise discrimination against chargers on account of their gender or by refusing to grant charges to persons on account of their gender. Okay, so where there is discrimination, where there is fraud, malpractices of any kind by on the part of the charges, the registrar is going to be, this is the registrar of lands, okay, is going to apply to the court under section 106. Okay, okay. So the exception to the discrimination on gender does not apply to a department of the government which is trying to promote maybe women access to property or something. So if they discriminate only on the uh, in their programs where they just want women, then that will not apply. Okay, but otherwise, if the chargee discriminates, then the registrar of lands will go to apply. So moving on, subsection 2, in reopening the charge, the court may do the following things. Okay, number 1, direct that the charge shall have effect subject to modifications that the court shall order. It will also require the chargee to repay the whole or part of any sum paid under the charge, okay, or any related or collateral, or any will require the chargee, sorry for that, require the chargee to repay the whole or part of any sum paid under the charge, okay. And my God, require the chargee to repay the whole or part of any sum paid under the charge, or any related or collateral agreement by the charger or any guarantor or other person who assumed an obligation under the charge, whether it was paid to the chargee or any other person. So it will require the chargee to refund the monies that have been paid to them. Okay, it will also require the chargee to pay any compensation to the charger, which the court shall think fit. Okay, it will also direct the chargee, being a corporate body, to cease acting in a discriminatory manner with respect to the granting of charges. So it will direct the chargee to stop acting, to stop discriminating against people based on their gender. Okay, if a bank, for example, only will grant loans, okay, against property on men only men, we don't want women, maybe because as a bank we think women are not capable or financially, I don't know why would anyone or women need maybe the consent of their husband. They only have like a small share to the property. It's not like the man or something. I don't know. So if such an institution does that, the court will direct it to stop doing that. Simple. So moving on, subsection 3. In considering whether to exercise the powers conferred on it by this section, the court shall have regard to the following things: to the to the age, gender, experience, understanding of commercial transaction, and health of the charger at the time when the charge was created. If the charger is an individual, okay, it will also have it will also look at the financial standing of the charger and the relative to those of the chargee at the time of the creation of the charge. I think the court will only reopen a charge where the charger, for example, was unduly was not in an equal position of power as the chargee during the formation of a charge. And this exercise of this power to reopen the charge only happens where the charger seems to the court that has been taken advantage of by the fraud or malpractices of the chargee, okay? uh, where maybe the chargee did not follow any of the provisions stated here, and now seeks to exercise the power of sale. Now, I always said yesterday during our discussion that the bank or whoever it is you took a loan from always has that greed that one day they will exercise the power to sell your property, okay, or buy it themselves. All right, so now this this the law is trying to protect here the vulnerable charger. In the case maybe they are an old person who was not on the same level as the chargee, maybe their financial standing wasn't that great and they gave their property to secure the loan on their property. They were duly uninfluenced, okay, you understand, unduly influenced, sorry, and okay, maybe the charger was under financial pressure at the time, okay, uh, maybe the interest rates prevailing at the time of the charge and during the continuation later were very different, okay, yeah, maybe if the chargee just increase those interests like crazy. You know, they normally do this, they increase the interest. You would think that if you borrowed 10 million from a bank, you could give them the title to your shamba that is worth like 20 million. So one day you'll be able to gather 10 million and pay them back. But I told you, their mentality is that they want that shamba, okay? Land or property appreciates with time. It does not depreciate, okay, it does not depreciate. So what they want is to own or rob you of that property. Now the law is trying to protect the charger who at that time was under pressure, okay, to for financial, needs. They wanted money and they needed that 10 million, but they thought they were going to repay it and then just take back their title. But the chargee, the banks normally increase interest so much such that in 10 years you or the whole sum that is owed, okay, is odd, is like exceeding even the your value of the land, in such a case. So the court is trying to protect the vulnerable charger from this. They will from they are trying to prevent the undue, what you call, the unjust exercise of the power to sell by the chargee. They are trying to prevent injustice, so they will reopen that charge. Any monies will be refunded back to, if paid to the refunded back to the charger, okay, by the chargee. Now, the degree of risk, the court will also look at the degree of risk accepted by the chargee, having regard to the value of the charged land and the financial standing and other resources of the charger. This we already said, okay. The importance of not undermining the confidence of reputable charges in the market for charges and any other factors that the court considers relevant. So all that you need to know is that while the law on charges against land seem to favor the chargee, okay, to protect their interests and everything. It also somehow tries to protect the charger and to have to require the chargee to have consideration for the charger, especially in respect where the property is community land or customary land, or in the case where the chargee commits fraud or malpractices or uses any undue influence, okay, or takes advantage of the charger's position. If it's an old lady who doesn't know, if someone who's under pressure for money, or all these things, they exist to have like that balance to protect both the business world of loans and banks, and also protect the person against whom their property is, against whose property the charge has been made. Okay, so that is a wrap up on the on charges. Thankfully, now we move to part 8 on compulsory acquisition of interest in land. Now, the first thing you need to know is that there is something called a preliminary notice under section 107 subsection 1. Whenever the national or county government is satisfied that it may be necessary to acquire some particular land under section 110, the respective cabinet secretary or the county executive committee member shall submit a request for acquisition of a public land to the commission. I have mentioned this just briefly before, that where a ministry wants a particular area to develop or build something, they will write a letter of request, okay, to the National Land Commission to, it's like entitling the National Land Commission to act on its behalf to start the procedure for acquiring that land. Okay, so first you need to know there's a request letter from the ministry or from the waziri, who is the cabinet secretary, to the National Land Commission. Then subsection 2, the commission shall prescribe a criteria and guidelines to be adhered to by the acquiring authorities in the acquisition of land. So the commission in response will draft the criteria required to be followed or the guidelines to be followed by the ministry who wants that land. Okay. So the third one is the commission may reject a request of an acquiring ministry to undertake an acquisition if it establishes that the request does not meet the requirements prescribed under subsection 2 and article 40 subsection 3 of the constitution. I don't know if you will allow me to get the constitution quickly. Just a minute. Okay, so let's see what Article 40 says. So, first, the National Land Commission can refuse the request if the ministry does not follow the guidelines prescribed under subsection 2, which we said. Then the other scenario is where it does not meet the requirement of Article 43. So, Article 40, okay, Article 40 of the Constitution, Article 43 says this: the state shall not deprive a person of property of any description or of any interest in or right of a property of any description unless the does this results from an acquisition of land or an interest in land or a conversion of an interest in land, uh, or is for a public purpose or in the public interest and is carried out in accordance with this constitution, and requires prompt payment of in full of just compensation to the person, allows any person who has an interest or right to access a court of law. Okay, so basically, Article 40 is saying that where the state cannot deprive a person of their right to own property unless it is for public purposes and unless the compensation in just what is it expedient, full, timely compensation has been done. Okay, so those are the conditions of Article 40, subsection 3. Okay, now if the ministry does not or is in contravention of that Article 4 subsection 3, then seriously the commission will reject the request. All right, moving on. In subsection 4, in the event that the commission has not undertaken the acquisition in accordance with subsection 1, the acquiring authority may proceed and acquire the land. Okay, so in the case where the cabinet secretary does not send a letter of request for acquisition of land to the National Land Commission, the National Land Commission will, the acquiring authority, will proceed and acquire the land. Okay? No, sorry. I mean, in the event that the commission has not gone ahead to acquire the land on behalf of the ministry, even after receiving the request letter, the acquiring authority or that ministry will just put on that code and start the process to acquire the land, okay, by itself. Now, subsection 5, upon approval of a request under subsection 1, the commission shall publish a notice to that effect in the Gazette. So once the National Land Commission receives the request letter from the from the who from the ministry to acquire the land, it will publish that notice. It will publish a notice to that effect in the Kenya Gazette and the County Gazette, so both at national and county level, and shall deliver a copy of the notice to the Registrar of Lands and every person who appears to the commission to be interested in the land. So the first step you need to know is a request letter is sent from the ministry to the National Lands Commission, after which the National Land Commission drafts criteria that to be followed or guidelines which must be followed, and the ministry adheres, and then the National Land Commission publishes a notice showing that a certain ministry wants to acquire a particular land in a particular area, uh, at both national and county level. Okay, so they will publish a notice in Kenya Gazette, National and County Gazette. Okay, and shall deliver a copy of the notice to the Registrar of Lands. So all key stakeholders will be informed. First, the public. Second, the Registrar of Lands. Third, the interested proprietors or the ones who uh, the proprietors of that particular land will be given notice. Now, upon service of the notice, the registrar shall make an entry in the register of the intended acquisition. Once the notice has been served, the registrar will make an entry in the register. So they are going to the registrar of lands is going to indicate in the register of land the the intended acquisition on that particular land. Okay, this is so that in case the the rationale would be that the proprietor of that land does not get, like, does not dispose of that property to another person, because already it will show whoever does the land search, they will see, oh my god. Oh my god. So whoever does the land search will see, the person will see that a certain ministry wants to acquire that land. So the notice will come up, okay? Whoever does this land search and is interested to buy the property will see that notice and will back off. So that is for the purpose. Now moving on, for the purposes of section 110 to 143, interested persons shall include any person whose interests appear in the land registry. So when the National Land Commission gives a notice to the Register of Lands, also they are going to ask for information on the proprietors of that land. So they will get the information as who are the owners, and those owners will appear obviously in the registry. So the only way to do it is to notice the Register of Lands and get the information on the proprietors, the owners of the land. So such notice will be given to the interested parties, to the spouses in case of matrimonial property, or in case that area also has is matrimonial property, in case of any person who is occupying the land, who is now in actual occupation of the land, they will also receive that notice, and the spouses of those people who are occupying that land. Moving on, subsection 8, all land to be compulsorily acquired shall be geo-referenced and authenticated by the office or authority responsible for survey at both the national and county government. Okay, so there will be a geo-referencing, that is the coordinates or something, I don't know, by the surveyors, okay, at both county and national level. So where the property is situated, if it's county, if it's national. So power of entry to inspect land, section 108. After the letter has been sent to the commission, the guidelines have been sent to the ministry by the commission, the notice has been published in the gazette and to the registrar and to all interested proprietors, all the proprietors of that land. The next step is to enter and inspect the land. Okay, all right, is to enter and inspect the land. So under section 108 subsection 1, the commission may authorize in writing any person to enter upon any land specified in a notice published under section 107 and inspect the land, and to do all things that may be reasonably necessary to ascertain whether the land is suitable for the intended purpose. So after the notice, the commission can order anybody on its behalf to enter the land and inspect it. Subsection 2, an authorization under subsection 1 shall not empower a person to enter a building or an enclosed court or garden attached to a dwelling house. So there is like a limit. When you're inspecting, you don't go to the residential apartment or building or home or dwelling house or the garden that is attached to that home, okay, unless that person has first obtained the consent. So you can enter the land, the adjacent land, the surrounding area, the compounds, but you can't enter the home in which that person is living or the garden attached to that home, okay, unless you obtain the consent of the person you will be seeing who is occupying that land or that home, or has served on the occupier and not less than 7 days written notice of the intention to enter. So you will either obtain the consent. Another way you can do this is you serve on the occupier of that land not less than 7 days written notice of the intention to enter. So you give them a notice that you are going to enter that dwelling house or that garden attached to it to inspect it 1 week before you show up. So moving on, payment for damage entry for inspection. Section 109. Jesus, God, I can't. There's a donkey in the background. He just won't shut up. I don't get it. So let's move on. Now, payment for damage entry for inspection. Section 109. Section 10. Section 109 of the Act talks about as soon as practicable after entry has been made under Section 108, the Commission shall promptly pay in full just compensation for any damage resulting from the entry. So, if there is any damage that it comes about from inspection by the authorized person, okay, any damage will also attract damages or compensation. So if they damage the property or the dwelling house or the garden or something, they will pay compensation. Okay, it's not them because they are agents acting on behalf of National Land Commission. The National Land Commission will have to pay damages if they cut down trees or something. So moving on, notice of acquisition and effect of acquisition on plant and machinery. Now section 110 subsection 1 says land may be acquired compulsorily under this part if the commission certifies in writing that the land is required for public purposes, okay, or in the public interest as related to and necessary for fulfillment of the stated public purpose. Now, I already said under Article, the one we looked at, Article 40 of the Constitution, Article 3, it's required that the government should not deprive title of any person to their property unless it is intended for public purpose or public interest. So in under section 110, it is reflecting that sub-article, okay? It is reflecting Article 4, Sub-Article 3 of the Constitution, which requires that this acquisition will only be valid if it is for public purpose, and the Commission will do so in writing, will certify that the land is being acquired for public purpose, okay? Subsection 2, if after land has been compulsorily acquired, the public purpose or interest justifying the compulsory acquisition fails or stops, the Commission may offer the original owners or their successors in title preemptive rights to acquire the land upon restitution to the acquiring authority the full amount paid as compensation. So where that use is exhausted or where it doesn't fall through, where the plans of the government to maybe build an oil refinery on that piece of property does not fall through, then the commission can offer to resell that land to the people, the former owners, okay, at that price they had received as compensation, because compensation is normally done at market price, okay, at that particular time. So they will, even if at later period the market price would have increased, the commission is still required to resell that property at the amount which was payable back then as compensation. So subsection 3, if any plant or machinery is attached or permanently fastened to the land, okay, the person interested in that plant or machinery may serve on the commission a notice in writing that such person desires to sever and remove the plant or machinery. After receiving the notice of intention to acquire the land under section 107, 5 and not later than 15 days before the inquiry appointed under section 112. So if any plant is found permanently fixed on the land, the person who is interested in that machine or plant has the meaning, I think, assigned to either the plant, the tree, or plant factory, I don't know. Or I'm just going too far, maybe it's just plants, the trees. So in if the person interested wants to keep the machine, okay, and they can cut the yeah, I think it's tree, so they can cut it or cut the machinery and what you call and attach or disconnect it from the land. They will they will after receiving the notice of intent to acquire the land, they will not later than 15 days before the inquiry appointed under section 1 or 112.1 inform the National Land Commission. So if you the name of that principle here, I think doesn't really apply. It's like it is excused because we know that any under the name of that principle, whatever is permanently fixed to the land, is it, yeah, permanently fixed to the land becomes part of the land. But here uh it's like Solo said it something but I forgot. If I'm wrong, just you can look it up yourself. So here the National Land Commission, if the person can disconnect or remove that machine or plant, then you are given permission. You just notify the commission that you are interested in that and you can remove it 15 days before the inquiry. Okay, now compensation to be paid under section 111 subsection 1. If land is acquired under this part, okay, just compensation shall be paid. So there are like three criteria. The compensation will be just, okay, it will not take away from the value of the land. So it will be just, it will be paid fast, that is prompt, and it will be paid in full, okay, to all persons whose interest in the land have been determined. All right, but I want you to know that, you see, under this section, there's a new act called the Land Value Index Act, which proposed, it's not a bill, it's an act, which is now trying to give the government more time to pay compensation, like 1 year, okay? So imagine in 1 year you have not received compensation from the government and you don't have your home or your land and you are homeless. So it really goes against the what the principles of natural justice, okay? So here you see that the Land Value Index Act is not only proposing uh, a land index that will determine the value of any land that the government wants to acquire, but it will also give the government two things. Number one, to continue their developments even when the owners are aggrieved. They have like a case at the tribunal. It also proposes for there to be a tribunal, okay, to hear cases related to compulsory acquisition of land, okay. Instead of going to the Environment and Land Court, a person first goes to this tribunal, okay. And even while the case is pending there to be discussed, or in any court of law, the government is allowed the act allows the government to continue its operations. If it's building something, continuing, as long as funds have been prescribed for it, have been budgeted, okay. So this is the Land Value Index Act. Really is, please take a look at it in your own time. It is really taking away the justice, okay, that should be protected, okay, and enjoyed by those owners to get a timely compensation. Number one, because it gives the government a grace period of 1 year that it can compensate within that 1 year. So my question is, during that 1 year, where will those people be staying if the land is their home? Where will they be getting their livelihood if that land is an agricultural land that they have been using to farm and get there to sell milk, to sell mboga mboga or tomatoes? Where will they be getting food? So the constitutionality of the Land Value Index Act, as far as these changes and compensation have been made, I wish someone would just go to court and challenge the constitutionality. Okay, it goes against Article 40 that we discussed of the Constitution. It goes against it totally. So I wish Katiba Institute or someone else would go to court and challenge the Land Value Index Act, okay? But don't tell the government. Anyway, moving on, the assessment of just. So So the subsection 2 of section 111 says the commission shall make rules to regulate the assessment of just compensation. So the commission will make the necessary rules to regulate the compensation, like the amount, market price, and all that. Excuse me, please. Moving on. Inquiry as to compensation. So section 112 says at least 30 days after publishing the notice of intention to acquire land, okay, the commission shall appoint a date for an inquiry to hear issues of propriety and claims for compensation by persons interested in the land. So this is basically that gathering, okay, to hear that gathering where now all those owners of the land are responding to the notice, okay? If it's about compensation, if it's to hear issues of property, okay, around ownership, okay, they will do so, okay? They will gather like all these people and tell them to go a certain place, a certain time, and they will hear them, okay? Now, under section 112, the the commission, after 30 days of publishing the notice, will also give another notice of the inquiry to be published in the Gazette. So they will give another notice in the Gazette after 30 days, okay, at least 15 days before the inquiry. So they will give a notice at least 15 days before the inquiry, so that if people are not there, they can travel and make themselves available, so that if people uh, just for planning purposes and to increase accessibility, okay? And also they will serve a copy of the notice on every person who appears to the commission, okay, to be interested in the property. So they will serve a notice to every person who appears to the commission to be the proprietor or to have interest in the land. But let me tell you, on the ground, this is not what really happens. Normally, people don't get hand delivered notices of the inquiry, okay? Uh, so I don't know who normally informs them, but they end up like not knowing. Some of them don't know where the venue of the meeting, the inquiry is. Some of them can't even show up. Maybe the the place is inaccessible for most of these people, they can't reach there. Okay, ni mashamba mashamba huko or something, I don't know. Mm-hmm. Okay, so mm-hmm. Now subsection 2. Subsection 2. The notice of inquiry shall call upon persons interested in the land to deliver a written claim of compensation. So once they they give the notice of the gathering, okay, they will also require the person to come with a written claim of compensation not later than the date of the inquiry. So on that same day, it's very important for you to know where that meeting is going to take place and for you to be there in time, not just empty handed. You go there with a written claim of compensation. Just write a letter indicating your parcel number of the land, indicating the market value at the time if you are smart, and then you the amount of acres and everything, and then you say you sign it off. Okay, you sign it off. So it's a written claim of compensation, and it should be presented with you um, alongside other particulars, personal details like your bank account, your ID, okay, and all those things. So let's move on. The notice of inquiry shall call upon persons interested to come with a written claim. At the hearing, the commission shall do the following: make full inquiry into and determine who are the persons interested in the land. So it will determine who are the persons who have interest in the land and will receive written claims of compensation from those interests in the land. So in case it's people who are occupying it, maybe it's not registered, they don't have the title, but they have like a possession interest. So those people also will be catered. But remember, the amount of compensation will not be the same for people who occupy without registration vis-a-vis the people who occupy with full title deeds. Okay, it varies. So the commission may postpone an inquiry or adjourn the meeting from time to time for sufficient reasons. Okay, now this postponement or cancellation is where people get screwed because they may think the meeting will happen on a certain date, then they don't get the updated information on the postponement or the change of venue or another place to another place, so they end up showing in a completely different place. Okay, so it's really important that the government that the parliament reviews the provisions under this section, because to make sure that stricter rules are imposed on the National Land Commission to do what? To inform the members. There must be like a strong regime or system of information that is supposed to be fulfilled or undertaken by the National Commission to ensure everyone is up to date with the meeting venue, where it will take place, what time, what is required of them to bring, okay, and so forth. So I also want to tell you that this meeting is not just an ordinary meeting. This meeting is like a court session where they will hear evidence of claims to the property, where they will hear people can call on their neighbors to testify that they have lived there for generations. Okay, they will act like a court. They will take oath and affirmations. They will do all these things. Okay, and the ministry also is allowed to send their representatives during that hearing. Okay, so that's all you need to know. So the commission will have the powers of the court to summon and examine witnesses, uh, to administer oaths and affirmations, to compel production and delivery of documents of title deeds. Okay, all these things it will do. Now, the public body for whose purposes the land is being acquired is entitled to be heard. Okay, to produce evidence and to call and question witnesses. Okay, so the ministry can also be there present and also be participating in this process. Now, award of compensation. Under section 113, subsection 1, upon the conclusion of the inquiry, the commission shall prepare a written award. So there is like once the hearing has been completed, the Commission shall prepare a written award, in which the Commission shall make a separate award of compensation for every person whom the Commission has determined to have an interest in land. Now, subject to Article 42 of the Constitution and Section 122 and 128 of this Act, an award shall be final and conclusive evidence of the size of the land to be acquired, the value, okay, of the land in the opinion of the commission. So it's not like the market value or something. The National Land Commission gives that land the value. Okay, I don't think if that is protecting the interest of the owner or what, but that is up to you to judge. Okay, so the amount of the compensation payable, whether the persons interested in the land have or have not appeared at the inquiry. So they will also, the constitution, sorry, I mean the award will be final. Just know that the award, whatever it is, whether it's the amount, whether the size of the land, whether it is the value of the land, okay, it's final. Oh my God. So the award is final. That is the amount, the size, the value, and will not be invalidated by reason only of a discrepancy which may thereafter be found to exist between the area specified in the award and the actual area. Now, this is where things go wrong. This is where review needs to be done, okay? Because most people find that the size that has been indicated in the compensation vis-a-vis the actual size that the government then takes are different. So they will indicate a smaller size in the award and award that's little compensation, maybe to 80 acres, while in reality they have taken 160 acres. Okay, where is the justice? I'm not an activist, but I'm just saying this leaves room for the commission to do as it pleases as far as allocation of award is done, because first it is final, the size, the value, the amount of compensation, all are final. You can't change, you can't appeal, okay? Cannot be invalidated by reason of discrepancy between the area specified and the actual area. Look at this. This is like saying the commission can actually on the ground take twice the size they have indicated in the award, and you can't invalidate it. Simple. That is what it is saying. Where are principles of natural justice? Yeah, just look for yourself, you will see. Now, this is now section 113, subsection 2. But let's read further. Maybe there are restrictions because it says subject to Article 42. Article 42 is subject 40. Subject. Article 42 says Parliament shall not enact a law that permits the state or any person to arbitrarily deprive a person of property of any description or right over any property of any description, or to limit in any way, restrict the enjoyment of any right under this article on the basis of any of the grounds specified. So it's contradicting itself. It says subject to Article 42 of the Constitution, but at the same time, oh my God. Okay, so Article 42 of the Constitution is saying that the Parliament should not enact any legislation that will deprive. But the Land Value Index Act is an example of a piece of legislation that has deprived the that has disadvantaged the the owners of land which is compulsorily acquired. Okay, just so you know. So section 122 we haven't read there, but we will and see what it means. Okay, so just know here that the award is final as to size, as to amount, as to value of the land. Okay, even if, and it can't be invalidated just based on differences between the actual size they have taken on the ground and the size reflecting on the award. Does that seem okay to you? Subsection 3. If an interest in land is held by two or more persons as co-tenants, the award shall state the amount of compensation awarded in respect of that interest and the shares in which it is payable to those persons. So it will specify the shares payable in case of co-tenancy. Every award shall be filed in the office of the commission. So every award will be filed and recorded in the National Land Commission office. Now, notice of award under section 114 subsection 1, on making an award, the Commission shall serve on each person whom the Commission has determined to be interested in the land a notice of the award and offer of compensation. Subsection 2. Upon acquisition of land and prior to taking possession of the land, the Commission may agree with the person who owned that land that instead of receiving an award, the person shall receive a grant of land not exceeding in value the amount of compensation which the Commission considers would have been awarded. And upon the conclusion of the agreement, that person shall be deemed to have conclusively been awarded and to have received all the compensation to which that person is entitled in respect of the interest in that land. Now, do you see this? This is why I tell you, go and look at the Land Value Index Act, because it has provided that it has provided alternatives to money when it comes to compensation. It's not just money that is going to be offered in the Land Value Index Act. It is what? It can be an alternative piece of land. But what the Land Value Index Act says that that land will be held in trust by the commission. Now, who would want an alternative piece of land held in trust by the commission? Who who will take that option? Also, another alternative option was bonds or treasury bonds. Okay, so now they'll make you an investor, whether you like it or not. There's nothing wrong with that. But like seriously, I think these options exist for them where the government does not have, or the ministry does not have enough money to compensate everyone. So they will give you these other options. They may look attractive, but just be careful while you are choosing. You are making the right choice for yourself. Now, if you receive the money, I would argue that receiving the money is the best option, because you will receive that money, then you go ahead and search for other pieces of land by your own and buy it, okay? Without any control by the commission, without delays, without anything. You will buy the land you like. If it's a house, you will buy the house you like. If it's nini, you will just have control. But if you take the option of alternative land, just know it will be alternative land with the same value as your own, and it might not be in the area that of your liking, of your choice. You may not even be able to access it. It could be in another county. It could also not be suitable for the use that you are using your previous land, okay? Also, it will be held in trust by the commission. Just know that, so you don't get yourself in the wrong trap, and then you're like, oh my god, I wish I told you. I'm telling you now, just keep that in mind, okay? Know everything, be well informed before you jump in anything. So here, this section 114 is giving those alternatives, okay? Okay, it's giving 114 in subsection 2 is giving the alternative of uh, another land instead of money, which you can find more details in the Land Value Index Act of 2019. The constitutionality of the provisions of that act are still in question, according to me. So just look at it, then you will know more. Now, so if you agree you want an alternative land, that agreement will be recorded in the award instead of the cash, okay? So moving on, section 115. Now, under section 115, it talks about payment of compensation. After notice of an award has been served on all the persons determined to be interested in the land, the commission shall promptly pay compensation in accordance with the award to the persons entitled thereunder, except in a case where so here in this section 115, the compensation is first. Is as soon as the notice of award has been served on on the the people who own the land, okay? But exceptions exist where there is no person competent to receive payment, okay? The person entitled does not consent to receive the amount awarded, okay? If you say no, this amount is too little, okay, there is dispute as to the rights of the persons entitled to receive the compensation, or as to shares in which the compensation is to be paid. So if in case of co-tenancy, the co-owners are in dispute as to the amount that has been specified to be paid to each one of them, then that one will be delaying the compensation, okay? So in any of the cases referred to in paragraph A, B, and C, all the cases we have seen where there's disagreement as to the shares, where there is disagreement as to the title, where there is uh, no person, no beneficiary to receive, okay, where the person does not consent to the amount, maybe it is very little. So what will the commission do? The commission may at any time pay the amount of the compensation into a special compensation account held by the commission, notifying any persons interested accordingly. So now, I don't advise for you to do these things. Okay, the law is like, I don't know why whenever it comes to the government, there are so many restrictions placed on the access to justice, okay, by the private parties. I don't know. Maybe someone should tell me. So this one is saying that where there is no person to receive, where the person does not consent to receive, where there is dispute as to the shares, the commission will simply not care. They will just open up a special account and put the same money inside there. It will be put there and the persons will be notified. So this money will be held by the commission on behalf of these people. All right, just so you know. So payment in error. So under section 116, if a person has received any money by way of compensation awarded for an interest in the land being acquired, either in error or before it has been established that some other person is rightfully entitled to the interest, the commission may by notice in writing served on that person require that person to refund to the commission the amount received, and the amount shall be a date due from that person to the commission. Now where there is a mistake on the part of compensation, where the commission pays the wrong person, okay, by mistake, that person will be entitled to refund the money. Now, grant of land in lieu of award under section 117 subsection 1, if the amount of any compensation awarded is not paid, okay, so where the amount of compensation is not paid, the commission shall, on or before the taking of possession of the land, open a special account into which the commission shall pay interest on the amount awarded at the rate prevailing bank rates from the time of taking possession until the time of payment. So if the amount of is awarded is not paid, like we said in the cases above, where the person is in disagreement, the shares over title, that refuses the amount, so the commission opens a special account, okay. So this is just repetition of the same. Shall open a special account. So it will open a special account into which the commission shall pay interest on the amount awarded at the rates prevailing. So if the what this is saying, that the cash that is placed in that special account will be accruing interest, that like there'll be an interest that will be accumulated on that amount. Now, subsection 2, if additional compensation is payable under section 120, there shall be added to the amount of the additional compensation interest thereon at the prevailing bank rates from the time when possession was taken or compensation was paid. So, if the commission opens an account to put the awarded money, that money won't just stay there. It will be getting the interest over that period until payment is done, okay. If there is additional compensation which is also required to be paid under section 120, we have not seen, we are going to see that that additional compensation will also attract interest, just so you know, okay. Moving on, survey where part of holding is acquired. Now, Section 118 of the Land Act says if part of the land comprised in documents of title has been acquired, the Commission shall, as soon as practicable, cause a final survey to be made of all the land acquired. Okay? So, if part of the land comprised in documents of title has been acquired, okay, so if some part of the land has been acquired, okay, the commission will make the surveyor to conduct a survey, okay, of the acquired land. Payment of interest. So section 119, whenever the survey provided for in section 118 discloses that the size of the land acquired is greater or less than the size of the land in respect of which the award has been made, compensation shall be paid for the excess size in accordance. So at least now we see that whatever in that section which was saying the award is final, the size, the amount, and the all those things, blah blah blah. Here at least we see that the in case a survey is done, if after survey is done, it is found that the land is actually greater than the size recorded in the award, the person will be paid excess compensation in proportionate to the excess size. Okay, so moving on, additional compensation where area found to be greater. So under section 120 subsection 1, only after the award has been made and the amount of the first offer has been paid, the commission shall take possession of the land by serving on every person interested in the land a notice that on a specified day possession of the land and the title to the land will vest in the national or county government as the case may be. Mhm. So the people will be notified where the when the National Land Commission will take possession and when the title would have been transferred to the government. Okay, it will be notified. The people will be notified. Okay. So in cases of where there is an urgent necessity for the acquisition of land and it would be contrary to public interest for the acquisition to be delayed by following the normal procedures of compulsory acquisition under this act, the commission may take possession of uncultivated or pasture or arable land upon the expiration of 15 days from the date of publication of the notice of intention to acquire, and on the expiration of that time, the Commission shall, notwithstanding that no award has been made, take possession of that land in the manner. Are you kidding me? So everything we have said is bull. All that procedure can be done away with. This is what Section 120 is saying. Why would you create a law that would give the procedure and then later on in the subsequent sections do away with the procedure? Why? In cases of where there is an urgent necessity, just based on urgent necessity, what could be so urgent? I don't know. You tell me. What could be so urgent as to make the National Land Commission do away with the whole process that this law has given? I don't know. Yeah, so this section 120 is saying that the commission can acquire the land 15 days after it has published the notice in the gazette. It will acquire the land and take possession. Okay, uh, and will also take possession even if no award has been given. Okay, and that circumstances allowing for that to happen is where there is an urgent necessity for the acquisition of land. So subsection 3, upon taking possession of land under subsection 1 or subsection 2, the commission shall also serve upon the following: the registered proprietor of the land and the registrar a notice that possession of the land has been taken and that the land has vested in the national or county government as the case may be. Subsection 4. Upon taking possession and payment of just compensation in full, the land shall vest in the national or county government absolutely free from encumbrances. Now, let's just move on. Some of the things in that I read are just too they go so much against the Article 40 of the Constitution that I don't know how this law got passed. Anyway, let's just move. Now, formal taking of possession and vesting, okay? Formal taking of possession and vesting. Under Section 121, subsection 1, if the documents evidencing title to the land acquired have not been previously delivered, okay? If the documents evidencing title to the land acquired have not been previously delivered, okay, the Commission shall in writing require the person having possession of the documents of title to deliver them to the registrar, and thereupon that person shall forthwith deliver the documents to the registrar, okay. So okay, once the National Land Commission is ready to take possession and the documents of title have not yet been handed over, the National Land Commission will write to the proprietors of land, giving them a notice and ordering them to submit the same to the registrar, okay, of lands. On receipt of the document of title, the registrar shall cancel the title documents of the whole of the land if the whole of the land comprised in the document has been acquired. So it will cancel the title deed in case the whole land is acquired. If only part of the land in the document has been acquired, it will register the resultant parcels and cause to be issued to the parties title document in respect of the resultant parcels. So it will register the tiny bits that are remaining, okay, to the owner. They will register those and then give the documents in respect of those tiny ones remaining. So subsection 3, if the documents are not forthcoming, the registrar will cause an entry to be made in the register recording the acquisition of the land under this act. So if the documents will not be handed over to the registrar, or the person refuses to hand over, the registrar will cause an entry to be made in the register recording the acquisition of the land, so that you cannot dispose of it. It will be recorded on the entry. Moving on, section 122, surrender of documents of title to the commission. Now, the powers of acquisition conferred by this part shall not be exercised so as to acquire a part only of a permanent building in any case. So, if that part is reasonably required for the full and unimpaired use of that building, if a person interested in the building decides that the whole of the building shall be acquired. So the powers of acquisition conferred shall not be exercised so as to acquire a part only of a permanent building. So in the case of a permanent building, the acquisition will not only be of a part of the building, uh, where a person interested in the building desires that the whole of the building shall be acquired. So it's like what I get here is that a part of a building, acquisition of just a part of a building, okay, shall not be as so as to acquire part only of a permanent building. I don't get this. Let's just write it. We move on. Section 122 question mark. All right. Now, mm, okay, let's just move on. Let's move on. Acquisition of other land on account of severance. Now, section 123, subsection 1. At any time before possession is taken of any land acquired under this act, the commission may revoke a direction to acquire the land. Okay. At any time before the National Commission has taken possession of the acquired land, they can revoke. Okay. They can revoke the whole thing and shall determine and pay compensation for all damage suffered and all costs and expenses reasonably incurred by persons interested in the land by reason of or in consequence of the proceedings for acquiring the land. So they can cancel anytime, and just like where the buyer cancels the purchase of the or breaches the contract of sale. The same here. The buyer is the National Land Commission. So if they revoke or cancel the agreement to sell, they can simply pay damages to the people who are affected. So subsection 2, the principles relating to the determination of compensation set out in the rules shall apply so far as they are relevant to the determination of compensation payable under this section. Okay, withdrawal of acquisition, section 124. If the commission is satisfied that the possession of any land is required by a public body for a particular period not exceeding 5 years, and that the following things: the possession of the land is necessary for public purpose, the possession of the land is necessary in the interest of defense, public safety, public, all the publics. The necessity, therefore, is such as to afford reasonable justification for the causing of any hardship that may result to any person having an interest over the property, and so certifies in writing possession of such land may be taken for that period under this section. So the where the government wants to take land for public purposes and to use that land not exceeding 5 years, okay, for a short term period, the who yeah who does the National Land Commission will possess such land, okay. Now the commission shall then serve on every person interested uh, on the land to be taken possession of under subsection 1, or on such of them as after reasonable inquiry are known to the commission and noticed that the commission is to take possession of the land for that period, okay. Subsection 3, at the end of 7 days after service of notices has been completed, the commission may, after paying the first offer of compensation, take possession of the land by entering personally or by agents on the land and positing on the land a notice in the prescribed form that possession has been taken, and shall serve a copy of the notice on the occupier. So it will simply write certifying that the government needs to acquire particular land for a period not more than 5 years, and then they will be compensated, of course, for that period that that land will be used. It's like a lease. You are leasing to the government. This section shall not apply where the use of land is likely to cause permanent damage to land. So thank God, even that thought passed my mind. I was like, what if that use would, even if it's for a short period, would damage the land so that it cannot be used by for the intended purpose by the owner later after the lease. So this subsection 4 comes in and says that it will not apply where the use of the land is likely to cause permanent damage. Now, section 125, power to obtain temporary occupation of land. Now, section 125, subsection 1, the commission shall, as soon as is practicable, before taking possession, pay full and just compensation to all persons interested in the land. So they will pay, the commission will pay full and just compensation. So here we already see a repetition of section 111. Again, it repeats itself. So number 2, an acquiring authority shall pay the first offer of compensation to the interested parties before taking possession. Okay. So restoration of land. Restoration of land. Under section 126, if the commission is satisfied that any land of which the occupation or use has been secured under this part is needed solely as a means of access to other land, like an easement or a right of way, okay? Like an easement. You need that land, the government needs your land in order to access another land, okay? What happens? The use of the land shall extend to the passage of vehicles of all kinds, including heavy machinery, whether owned or operated by the public body occupying or using the land, or by any contractor. So, where the government wants to use your land in order to access the other land that is across from yours, tractors can pass there, vehicles, lorries of any types. The compensation to be paid under section 120 shall be limited to the damage done to the trees, plants, growing crops, and permanent improvements on the land. So whatever compensation will be paid will be subject to the damages that have been caused on your property while they are exercising or while they are using your land to pass or access the other land. Okay. Now, section 127, reference of matters to the court for determination by the commission. All right. The commission may at any time by application in the prescribed form refer to the court for its determination any question as to the following things: the construction, validity, or effect of any instrument, okay, the persons who are interested in the land concerned, the extent or nature of their interests, the persons to whom compensation is payable, the shares in which compensation is to be paid to tenants in common, the question whether or not any part of a building is reasonably required for the full and impaired use of the building, um, or the condition of any land at the expiration of the term for which it is occupied or used. Okay. So during this whole acquisition process, in case there are any issues arising as to the shares, to the validity of any act, to the persons who are interested, to the people who compensation must be paid, to the anything really, the National Land Commission can apply to court for these issues to be determined, okay, by the court. without prejudice to the powers of the court. Under this part, the cost of any reference to the court under subsection 1 shall be paid by such person as the court may direct, or where the court does not give direction, by the commission. So cost of the case to determine these issues will be paid by the commission, okay, or any person that the court directs. Now, reference to the Environment and Land Code, section 128 says any dispute arising out of any matter provided for under this act may be referred to the Land and Environment Court for determination. Okay, so any dispute arising out of any matter, I said, under compulsory acquisition will be referred to the Land and Environment Court. So the jurisdiction is on the Land and Environment Court. And then, just so you know, look at the Land Value Index Act. The Land Value Index Act proposes the creation of a tribunal, a land acquisition tribunal, which is going to have first to hear the matter first and put the Land and Environment Court at the stage of appeal. If you are not happy with the decision of the Land Acquisition Tribunal, you go to you appeal to the Land and Environment Court. So it's the court of second instance. Excuse me, sorry, I'm just so tired. Mm-hmm. Mm-hmm. Now, right of entry. Section 129. The Commission and any officer or person authorized under Section 108 shall, upon notice, have the right at all reasonable times to enter upon any land in furtherance of any of the purposes of this Act. All right? So the Commission and any officer or person authorized under Section 108 shall, upon notice, have the right at all reasonable times to enter upon any land in furtherance of any of the purposes of this Act. Mhm. So this is what I said, yeah, that the right of entry in taking possession or in surveying or inspecting, the commission will authorize people on its behalf to do these things, okay? To inspect, to do what. But the commission will also pay damages where any injury has been caused to the building or the land or something. So, section 130, I will stop here, take a break for 10 minutes, and then I will come back and we race to the finish line. Okay? Excuse me. Alhamdulillah, excuse. All right, so let's continue, please. Let's continue. Can you hear me? Moving on. Section 130. Okay. Penalty for obstruction. A person who willfully hinders or obstructs the commission or an officer or person mentioned in section 129, okay, in doing any of the acts authorized or required, okay, by this act, or who willfully fills up, destroys, damages, or displaces any trench, post, or mark made or put on land under this act commits an offence and is liable on conviction to imprisonment for a term not exceeding 5 years or to a fine not exceeding 3 million shillings or to both. Okay, so what this is saying is simply this: a person who obstruct the National Land Commission or anybody acting on the behalf of the NLC in carrying out the process of compulsory acquisition, such as, for example, uh, like maybe obstructs the surveyor from surveying the land or the inspector from inspecting the land, or removes the beacons or marks that the NLC puts on the property, on the boundaries, okay, commits an offense and is liable for imprisonment for a term not exceeding 5 years or to a fine not exceeding 3 million shillings, okay, or to both. So you see, this one also restricts the person from uh, it restricts the people from preventing this process from taking place, okay. So this fine is very hefty, like 3 million shillings is a big fine, and 5 years is a long time to be in jail. So, service of notices under section 131 1, a notice which may be given under this part may be served on a person by delivering it to the person personally. So, the notice which may be given under this part may be served on a person by delivering it personally or by sending it by registered post to the person's address. So, imagine most people I know whose land has been acquired in this way don't even have post office boxes. They don't have any addresses. They don't have any mailboxes registered anywhere. Okay. Another method the notice can be given is sending it by registered post. I said that to the person's address. If the whereabouts of the person or address cannot, after reasonable inquiry, be ascertained by leaving it to the occupier of the land concerned. So, whoever they will find on that piece of land when they go to check is the person they will give it the land to. Sorry, the notice to. If there is no occupier, by affixing it upon some prominent part of the land. So if they go to the land and they find there's no one there, they will affix it to a tree. They will affix it to a tree or a building that is there. If the person is a body, corporate, society, or other association of persons, by serving it personally on a secretary, director, or other officer thereof, or on a person concerned or acting in the management thereof, or by leaving it or sending it by registered post addressed to the body, corporate, society, or if there is no registered office at any place where it carries on business, or if there is none, uh, leaving it with the occupier of the land. If there's no occupier, by affixing it upon some prominent part of the land. So it's important that you check your post, you check your box. It's also important that you um, go to check on the land, okay, on your land. Don't just buy land and then migrate to Dubai and forget about it, okay. Likely that land will either be occupied by, who are they called, squatters, who after 12 years of uninterrupted stay are going to claim an interest in that property through adverse possession. Or the worst, you could not even know if your land is part of the land that is being acquired by the government, okay. Yeah, just so you know. Now, the Commission may, in addition to serving notice by paragraph C and D, place an advertisement in two newspapers with a national circulation. So there will be, the notice will be in newspapers. I know people, like where I am from, in my village, people don't read newspapers. We just didn't grow up seeing anyone read, so we don't either. I don't know whether it's bad or it's good, but that's just how it is. So imagine, and the newspapers, by the time they reach our village, the whole things have passed, like a whole half day or even a whole day has passed. We get the, like the, who would read a paper for the previous day and pay 60 bob for it. 60 shillings is a lot of money to someone from my village just to buy a newspaper. I'm just saying. Okay, so and most don't have like smart devices. They can't to subscribe to the online version. So you can imagine, it's this process needs revision. Just as far as many things, one of them being communication to these people through the notice. Yeah. Exemption from stamp duty. Now, Section 132 says this: stamp duty shall not be chargeable for an award or agreement made under this Act, and no person claiming any such award or agreement shall be liable to pay a fee for a copy of the agreement. So, we are being told that stamp duty shall not be chargeable for an award or agreement made under this Act. Okay, so there's no stamp duty payable. Okay, in this compulsory acquisition. Rules. Now, Section 133 is on rules. The Commission may make rules general for carrying out the purposes and provisions of this part. I don't know if such a subsidiary legislation exists about the rules for compulsory acquisition, but I'm going to find out. It must be there. If this Section 133 is requiring the Commission to create rules, then they must be there. Anyway, we are moving on to part 9. Settlement programs. So establishment of settlement scheme. Under Section 134, subsection 1, the Commission shall, on behalf of the national and county governments, implement settlement programs to provide access to land for shelter and livelihood. So the Commission will implement settlement programs to provide access to land for shelter. Yeah, just like the one in Peketoni, I told you, in Peketoni settlement scheme, it was during Kenyatta's time, and people came from central Kenya to settle in Lamu, in Peketoni area, From the time it was just bushes and woods and wilderness, now it's like thriving. It's like this business center, and people ride motorcycles, including women, and people grow crops and produce. They come to sell here in town. So it's like it has all these special plans like for roads and stuff. Yeah. So establishment of settlement scheme. Number two, settlement programs shall, for the purposes of this Act, include but not be limited to provision of access to land to squatters. Okay, so this settlement scheme is all about providing access to land to squatters, persons displaced by natural causes, development projects, conservation, internal conflicts, or other such causes that may lead to movement and displacement. So this section 134 subsection 2 provides scenarios where the National Land Commission will implement a settlement program where there is natural causes like floods or earthquakes, where there is like conflict or war and people are displaced, where the people have no land, they are simple squatters. All these scenarios uh, will make the will qualify for settlement program. Okay, now subsection 3, the commission shall uh, Subsection 3, the Commission shall assist the national and county governments in the administration of settlement programs. So the Commission will assist the national and county governments to administer settlement programs. Are we together until there? Mhm. So, subsection 4, identification of beneficiaries shall be carried out and verified. Okay. Uh, by a sub-county selection committee comprising of the following people: a sub-county administrator who shall be the chairperson, a representative of the county government, okay, approved by the county assembly, a representative of the commission, a national government representative, representatives of persons with special needs, a women's representative, and a youth representative. Okay. So it's like who will benefit from this settlement program? What are their names? Which criteria? All this will be carried out and determined by a committee. This committee is called a selection committee, and it's at the sub-county level. So we'll have the sub-county administrator who will be the chair. We can have someone from NLC. We can have someone from a women's organization, a youth organization. We can have special needs organization, national government representative, representative of county government. All these people will come together and form a special selection committee to identify the beneficiaries of this settlement scheme. Okay. Now, subsection 5, the Commission shall reserve public land for the establishment of approved settlement programs. Okay, and where public land is not available, purchase private land subject to the Public Procurement and Disposal Act or any other law. So the Commission shall reserve public land for the establishment of, so whichever land that goes or becomes the settlement scheme will be public land, not private land. And where there is none, the government will purchase that land, okay, under the following the principles in the Public Procurement, okay, Act. Mhm. Upon planning and survey, land in settlement schemes shall be allocated to households in accordance with national values and principles under Article 10 of the Constitution of Kenya and the principles and of land policy provided in Article 60. Let's look at Article 60. Principles of land policy, okay? Land in Kenya shall be held, used, and managed in a manner that is equitable, efficient, productive, and sustainable, and in accordance with the following principles of equitable access to land, security of land rights, sustainable and productive management of land resources, transparent and cost-effective administration of land, sound conservation and protection of ecologically sensitive areas, elimination of gender discrimination in law, customs, and practices related to land and property in land, and encouragement of uh, communities to settle land disputes through recognized local community initiatives consistent with this constitution. Okay. These principles shall be implemented through a national land policy developed and reviewed regularly by the national government and through this policy exists. Okay, so if you want to know more about it, you can check it out. The national land policy. So now, so any upon we are told that upon planning and survey, land in settlement schemes shall be allocated to households in accordance with national values and Article 10 and the principles of equitable access, security of land rights, and all those under Article 60. Okay. Any land acquired in a settlement scheme established under this Act or in other law shall not be transferable except through a process of succession. So this land is only transferable upon transmission. Okay. No, succession, I don't know if it's the same as transmission upon death of a person to the children. So any land acquired will not be, this land is only to make sure that you have a place to stay and protect you from conflicts and all those things. It's not land that you will get and dispose of to another third party. It's land that you will use and you are restricted from selling. Okay. Beneficiaries of land in settlement schemes shall pay a sum of money as may be determined from time to time by the Commission and the body of trustees responsible for settlement matters. So we are told that the beneficiaries of land in settlement schemes shall pay a sum of money as may be determined from time to time by the Commission. All right. So beneficiaries of land shall pay a sum of money that will be determined by the Commission. So this comes as a surprise because I thought the government is doing this to rehabilitate this group of people. So why would it require them to pay money from time to time? Okay. But anyway, maybe I will find out. So, subsection 9, the funds provided by the national government and county governments for the purposes of the settlement programs shall be administered in accordance with the law relating to public finance management. Okay. Yeah. So Land Settlement Fund, Section 135, subsection 1, there is established a fund to be known as the Land Settlement Fund, which shall be administered by the National Land Commission. So the National Land Commission will establish this fund for settlement only. So subsection 2, there shall be paid into the fund any monies appropriated by Parliament for the purposes of the fund. So there will be money that is going to be put in the fund. Any funds provided by bilateral or multilateral donors for the purposes of the settlement fund. So any donors who give grants for the settlement fund, it will go there. Gifts, grant, donations, or endowments as may be given to the Commission is also going to go there for the purposes of the fund. Monies that may be borrowed by the Commission for the purposes of the fund. Okay. The rates, charges, dues, or fees levied by the Commission under this Act. Okay. Uh, all monies derived from the payment made by beneficiaries of settlement schemes. So, beneficiaries of the settlement schemes pay money. Okay. Such sums as may be payable to the Commission pursuant to this Act or any other written law. So, subsection 3, the fund shall be applied to the following purposes. Number one, provision of access to land. So there is the purposes of the fund will be for provision of access to land to squatters, okay, to displaced persons, for development projects, for conservation, or such other causes that may lead to movement and displacement. So this repeats the section 132 through 134 about the scenarios where a person where the people are given settlement uh, schemes, that is those scenarios of squatterhood, displacement, development projects, conservation, and any other causes, natural causes, disasters, floods. So purchase of private land for settlement programs. So this fund will be used to purchase private land. I told you that the land on which the settlement scheme is done is normally public land, but where there is none, the government will purchase private land, okay, for the purposes of turning it into a settlement scheme. Establishment and management of refugee camps. So these refugee camps we know, okay, in Kenya, they come from the pockets of the settlement fund, okay. Provision of shelter and a livelihood to persons in need of settlement programs, okay. Provision of shelter and a livelihood to persons. Yeah, we know research, documentation, and sharing of information on settlement programs, any other purpose that would enhance the development and promotion of settlement programs, okay? So the fund shall be administered in accordance with the provisions relating to public funds under the law relating to public finance management. In carrying out its functions under Part 9, the Commission shall consult and cooperate with the departments responsible for land, finance, agriculture, environment, and natural resource, and special programs, and with the relevant county governments. So all the stakeholders will be involved in carrying out the settlement schemes. Okay, so part 10, easements and analogous rights. Okay, so under part 10 we are talking about easements and analogous rights. So the section 136 is saying in this part, unless the context otherwise requires, the land for the benefit of which any easement is created is referred to as the dominant land. Okay, so and the land of the person by whom an easement is created is referred to as the servant land. So one land is a servant to another land. It is being used to access another land. That is what an easement is. Those are the terms. Now, an easement is in relation to the dominant land referred to as benefiting that land, and is in relation to the servant land referred to as burdening that land. So an easement is in relation to the dominant land referred to as benefiting that land, and is in relation to the servant land referred to as burdening. Obviously, any servant is burdened. Any servant is burdened by an easement, any servant land. Now, subsection 2, subject to the provisions of this part, an easement shall be capable of existing only during the subsistence of the land or lease out of which they were created. Okay, so subject to the provisions of this part, an easement shall be capable of existing only during the subsistence of the land or lease out of which they were created. The subsistence of the land on lease or lease of which they were created, or in any other manner provided by any other legislation. Now, moving on, application of this part, section 137.1. This part shall apply to all easements made or coming into force on or after the commencement of this act. Okay. Subsection 2, subsection shall not, unless stated specifically otherwise, apply to easements, profits restrictive agreements, and all other like restrictions on the use of land having effect in customary law only. So this will not apply to easements, profits, or restrictive agreements and all other like restrictions on the use of land having effect in customary law only. I don't understand this, but I think will not uh, customary land will not have easements. Okay, that's what I'm getting. Subsection 3. In this part, reference to analogous rights means an access order made under, I don't know, it's one section 4. So, nature of easement, section 138. Subject to any other written law applicable to the use of land, the rights capable of being created by an easement are the following. Number 1. Any rights to do something over, under, or upon the servant land. Okay. So any right to do something over, under, or upon the servant land creates an easement. Any right that something should not be so done. So it's not only about doing something over it, under it, or upon it, but excuse me, any right that you should not do which will restrict you. But this becomes a restrictive covenant, isn't it? But I don't know. So any right that something should not be so done also creates an easement. Any right to require the owner of servant land to do something over, under, or upon that land. See, this is yeah. So any right to require the owner. If so, the first type is any right to do something which the dominant land has to do something over the land. Let's say to pass over the land. Okay, to get to his land, that is an easement. Any right that something should not be so done. Any right that the servant land should not do on that piece of land for the interest of the other one is an easement. Any right to require the owner of the servant land to do something over his land, okay, is also creating an easement. Any right to graze stock on the servant land is also an easement. So any right you have to graze your animals, okay, on another piece of land uh, freely as you wish, that creates an easement. Okay. So, subsection 2, the rights capable of being created by an easement do not include the following. So, they do not include any right to take and carry away anything from the servant land. So, an easement does not include, okay, the right to take something from the land or the right to the exclusive possession of the land, okay? Those things do not include an easement. So subsection 3, unless an easement has been created for a specific period of time which will terminate at a fixed date in the future, or on the happening of a specific event in the future, or on the death of the grantor, the grantee, or some other person named in the grant, an easement burdens the servant's land and runs with the land for the same period of time as the land or lease held by the grantor who created that easement. Okay. Okay, so unless otherwise specified that the easement is only for a certain period, let's say like 3 years, the easement is permanent. If it's a freehold land, it goes forever, perpetually. If it is leasehold land, it goes for that period of that lease. Okay, and okay, so it runs with the land the way it is. I hope you understand. Subsection 4. Subject to the provisions of this part, an easement shall be capable of existing only during the subsistence of the land or lease out of which it was created, which is the same as saying it runs with the type of land. If it's a leasehold, then that lease subsists. When it ends, the easement ends. If it's a freehold, that freehold exists, the easement exists. If it ends, it ends. I think when another owner takes over, I don't know, but we shall see. So entry on neighboring land where easement is refused. So section 139, an owner of any dominant land may apply to a court on the prescribed form for an order referring to as an entry order authorizing his or her entry on or over any servant land for the purpose of erecting, repairing, adding to, painting, or demolishing the whole or any part of any structure on the dominant land, or doing any other necessary or desirable thing on that land. So, where someone needs to access your land to get to their land and you refuse, that person has can apply to the court, okay, for an entry order, okay. So, if it is required that he needs to use your land to get to his land for the purposes of maybe building a building or painting or something, and you refuse, they are entitled to apply for a court order or for a court entry order, okay. The applicant shall give not less than 14 days notice in the writing to the owner of the servant land. So the person will give you not less than 14 days notice. The local authority having jurisdiction in the area where the dominant and servant land are located of the intention to apply for an entry order. So not only will he serve you a notice as the owner of the servant land, he will also serve to the local authority in the area. So subsection 2, on an application under subsection 1, the court, after hearing the applicant and the persons to whom notice was given under subsection 2, may make an entry order authorizing the applicant to do all or any of the following. So, the court will order for the following: to enter on or over the servant land, either personally or through the applicant's employees, agents, or contractors for any purposes if you are building. Now, to use for that purpose on or over the servant land any vehicles, okay, and other means of transport and any plant machinery, cranes, or other equipment. To store on the servant land such materials as may be required for the purposes of the work, okay, and in any quantities that are specified in the entry order. Are we clear? We are clear. So this simply says that the court order will revolve around around the need of that of the dominant person. If he needs to use your land to as a pathway for vehicles to pass, for fundis to pass, to enter, or for him to store materials, okay, then that court will grant. Okay, now subsection 3. In determining whether to grant an entry order under subsection 3, the court shall have regard to the following. Now, the nature and conduct of the negotiations, if any, between the owners of the dominant and servant land, where the dominant owner wants to obtain an easement, okay, the urgency or importance of the work which needs to be done, the scope of the work and the length of the time, okay. All right, are we together? The scope of the work and the length of the time, whether the applicant has applied for or obtained permissions, licenses, consents for the work that wants to be done from the public authorities, okay. Any other matters that shall appear to the court. So the court, in determining whether to grant this entry order, will look at this, whether the applicant has gotten the relevant license and permissions to construct, if he's constructing from the relevant public bodies, whether the whether this whether there are any negotiations existing between the dominant person and the servient person, whether the time, the scope of the work to be done, the duration of the work will be, and the urgency of the uh, of that work that needs to be done. Is it so urgent? Okay. Subsection 4, an order made under subsection 3 may be made on any condition. So this order, entry order, is not absolute. It is limited by the following conditions: the period of time during which the entry on or over the servant land is authorized. So it will specify the time, the hours of the day during which the work may be done, the preservation of safety of the persons living in that land, the preservation uh, of natural features and condition of the servant land, the restoration of the servant land to its former state after you have done the work, the maintenance of adequate access to servant land. You should not block access by the servant owners. The provision of security or indemnity to secure, okay, the performance of any conditions of the entry order, the making good of any damage caused by entry on or over the servant land, the reimbursement of the owner of the servant land for any cost, expenses, or loss arising from the entry, and any other relevant matter. So this is all about protecting the servant land owners in case of damage of their land upon the granting of the entry order. Okay, these are the conditions. Now, subsection 5, if as a result of fire, civil commotion, or natural disaster, a structure on the dominant land has become a threat to public safety or health, and there is an urgent need to effect repairs to or demolish that structure, and such action may only be executed by entry on or over the servant land, the owner of the dominant land may enter the servant land and effect the repairs after giving at least 24 hours notice in writing to the owner of the servant land, but the entry and execution of work shall not prevent the owner of the servant land from applying to the court for an order requiring the owner of the dominant land to make good any damage caused by the entry and works, and to reimburse the owner of the damage or cost. So this is saying section 5, subsection 5 is an exception of applying to the for the grant order. Okay, section 5 is an exception to the application of the grant order. Okay, the entry order. So in this case, the dominant owner is excused from the process of application and can simply just give the notice, 24 hours notice, okay, to the person. Instead of 2 weeks notice, you give just 24, and this is in the result of a fire, civil commotion, or a natural disaster on that building or on that dominant land, which needs to be urgently repaired. But also in the person, the servant owner will will apply to court to require to ask for compensation in case of any damage. So subsection 6, in this section, an owner of land includes an owner under a lease, a lessor, and lessee. Okay, so in this section, an owner of land includes an owner under a lease, a lessor, and lessee. All right, and neighboring land means any land in respect of which an order is sought under this section. Okay. Okay, so access order, section 140. An order of landlocked land may apply in the prescribed form to a court for an access order granting reasonable access to that land. Okay. Subsection 2. A copy of the application shall be served on the owners of each piece of land adjoining the landlocked land. Any person claiming an interest in any such piece of land of whom the applicant has actual notice, the local authority having jurisdiction in the area where the landlocked land is located, any other person occupying or having an interest in land which in the opinion of the court may be affected by the granting of the application. So this is the same, it's just the difference is landlocked. So the application is made to the court. It's called an access order, okay? The other time it's called an entry order. This is an access, and the owners are given the application, okay? A copy of the application, the owners of those adjoining land, the person claiming interest, the local authority having jurisdiction, and any other person occupying the land. So, subsection 3, the court, after hearing the applicant and any person served with an application under subsection 2, may make access order in respect of any other piece of land, the owner of which was served with a copy of the application under subsection 2 for the benefit of the landlocked land. So, the court, after hearing the applicant, may make access order in respect of the other piece, the piece of land. Okay. So, subsection 4, in considering whether to grant an access order, the court will consider the following: the nature of the access, the circumstances in which the land became landlocked, the nature and conduct of negotiations, just like the previous one, the hardship that may be caused to the applicant by the refusal of access order, the purposes for which access is or may be required, any other matter that appears to the court to be relevant. Okay. Now, subsection 5, an access order may be made subject to any conditions, including the period for which the access order is to be made, the payment of reasonable compensation by the applicant to any other person. Uh, these conditions are the same, okay? The period, the payment of compensation, the allocation of the cost of anyone, the fencing of any land and upkeep, the upkeep and maintenance of land, the execution of any instrument or the completion of any prescribed form, any conditions set out in subsection 4, which in the opinion of the court are applicable to an access order, and any other relevant matter. Subsection 6, an access order made under this section shall be deemed to have all the characteristics and incidents of an easement, and the land over which it has been granted shall be deemed to be the servant land. So this access order is the same as the entry order, because the right that is being exercised is the right of easement, or the interest of easement. It's the same interest. So that is that. Just a minute. So we see the following things here. Easement, if refused, one can apply for an entry order, and the court will look at the nature of the work, the period, the scope, the urgency, the everything, and will grant it based on conditions. Okay. Conditions include restoration of the state of the land after you are done with your work, the payment of compensation in case of any damages in that land, and all other things. So then there's something called an access order. It's just the same interest, which is easement, except it's landlocked. Like, just imagine a building is surrounded by others and they have no access of way except if they use the other land. Okay, so in such a scenario it's not called an entry order, it's like an access order. And the court will also look at the same things I have said, such as the the things I have said. What did I say? Any negotiations, if they exist, the the consequence or inconvenience of that person, the hardship if it was denied, all those things. All right, how it became landlocked and stuff like that. So, enjoyment of easement and analogous rights, section 141. The benefit of an easement and an analogous right granted under this part shall, during the term of its existence, be enjoyed by the owner of the dominant land and that owner's successors in title and by the following. So, the benefit of an easement will be enjoyed, okay, by the owner of the dominant land or the owner's successors and the heirs, okay, if he dies, or any lessee of the dominant land, or any lender on the security of a charge for the time being in possession of the dominant land. So, in case that dominant land has a charge, the chargee. So, the chargee is also going to enjoy that right of easement. Mhm. Who has taken possession? The chargee who took possession. You remember we talked about the chargee who takes possession by placing himself on that property. Subsection 2. Any person referred to in subsection 1 A and B who is entitled to the benefit of an easement or analogous right may take in the person's own name any proceedings necessary to enforce that easement or those analogous rights. So any person referred to in subsection 1A and B who is entitled to the benefit of an easement or analogous right may take in the person's oh my god, I'm so tired, excuse me. May take in the person's own name any proceedings to enforce that easement. So if someone wants to enforce the easement, they simply just issue, like, start a suit. Okay, so cancellation and extinguishment of easements and analogous rights. So what happens where easements and analogous rights have been cancelled or extinguished? What happens? So, cancellation and extinguishment of easements and analogous rights. Section 142. Subject to subsection 3. Any easement granted under this part or any analogous rights created under this part may be cancelled by the person occupying the dominant land. So, the person in whose interest or in whose favor the easement was created can cancel it. Okay. Any cancellation shall be effected in the prescribed form, and the easement or analogous right shall be extinguished on the date that the cancellation is recorded in the register. So, any cancellation shall be effected in the prescribed form, and the easement or analogous right shall be extinguished, okay, on the date that the cancellation is recorded in the register of lands, okay. On the application of any person occupying surveyed land, the registrar may cancel any easement, okay, or an analogous right if the registrar is satisfied of the following: that the period of time for which the easement or right was intended to subsist has expired. So, on expiration of the agreed period, the easement would operate, and the servant owner can apply to the registrar, okay, to cancel the easement. Number two, the event upon which the easement or analogous right was intended to terminate has occurred. So uh, where in the case that the an event, it was agreed that a future event would terminate the easement. So when that event happens, it will like the registrar will deem it to be cancelled. So section 4, the consent of any lessee or lender for the time being entitled to the benefit of any easement or analogous right shall be necessary for the cancellation of any such easements or rights, and such consent shall be given in the prescribed form. So subsection 4 is saying the consent of any lessee or lender for the time being entitled to the benefit of any easement or analogous right shall be necessary. So in order to cancel the lease, you need the consent of, sorry, in order to cancel an easement or analogous right, you need the consent of the lessee, the one who is the third parties, yeah, who are going to be affected, the lessee or lender. Okay, so you need the consent of the third parties who would be otherwise affected if you cancel the lease, sorry, the easement. So we have something called public rights of way. Now, under section 143 on power of the commission to create public rights of way, the subject to and in accordance with this section and section 146, the commission may create a right of way which shall be known as a public right of way. A public right of way may be a right of way created for the benefit of the national or county government, a local authority, a public authority, or any body to enable that organization to carry out their functions, okay? To carry out their functions referred in this act as a way leave, or a right of way created for the benefit of the public referred to in section 145 as a communal right of way. So where the commission creates a right of way and declares that this place can be used for people to pass, it will be a communal right of way. Where it declares that this part will be used for the department in fisheries, county government, or something to use for their day-to-day activities, then it will be called away leave. Okay. My god, I'm so tired. Let's move on. Subsection 3. Subsection 3, a public right of way shall attach to and run with the servant land in respect of which it has been created, and shall be binding on all owners from time to time of the servant land. Okay, so a public right of way will attach and run with the servant land and shall be binding on all owners, even subsequent owners of that servant land, and any manner they are occupying the land, whether under a land or a derivative right, or under customary or successor, or as a trespasser, they will be bound by the public right of way. So a public right of way will go with the land forever until the day of judgment. A way leave shall authorize persons in the employment, okay, so a leave shall authorize persons in the employment to or who are acting as agents of or contractors for any of the organizations, authorities, and bodies to enter on the servant land for the purpose of executing works, building and maintain installations and structures, and inserting all such works, installations, and structures on the servant land, and to pass and repass along that we live in connection with purposes of those organizations, authorities, or bodies. So what it's saying is the way live which we said was created for authorities, public department, all that will enable anyone who is an agent of them to use it, contractors, okay, just anybody will be entitled to use that land. All right, anybody. All right, so a communal right of way created for the benefit of the public shall entitle the public to pass. So the people can pass, repass, pass again and again along that right of way and in areas designated for that purpose to undertake recreational activities or other prescribed activity of the kind permitted in that area. So they can do anything, pass, run, anything. Application for way leave. So under section 144, subsection 1, unless the commission is proposing on its own motion to create a way leave, an application for the creation of a way leave shall be made by any state department. So any state department or authority or county government or public authority or a corporate body will apply to the commission for to create a way leave. Subsection 2. An application shall be made in the prescribed form and shall be accompanied by any prescribed information or other information that the Commission may in writing require the applicant to supply, and the Commission shall not begin the process of creating a way leave until all prescribed or required information has been submitted to it. So this is saying is an application shall be made in the prescribed form and shall be accompanied by any prescribed information or other information that the commission may in writing require the applicant to supply. So the application will come with information as to perhaps the need of the way leave, what it will be used for and stuff, okay? So in subsection 3, in order to enable a proposed way leave to be created by the Commission of its own motion to comply with the provisions of this section, the Commission shall complete an application form as if it were applying to create a way leave, and references to the applicant in this subsection in relation to an application to create shall be taken to apply as well to the Commission. So the Commission can create a way leave in two scenarios: on its own motion, where it becomes the applicant, or on the motion of a relevant authority. Just know that. These all other stories, they are not really important. Subsection 4. The applicant shall serve a notice on all persons occupying land over which the proposed way leave is to be created. So in case it is the relevant department, it will do so. In case it is the National Land Commission, it will do so. It will give notice on the people occupying the land, including persons occupying land in accordance with customary pastoral rights. Number 2, the county government in whose area of jurisdiction land over which the proposed way leave is to be created is located. So they will also give notice to the county government. They will give notice to all persons who are occupying the land, okay, and any other interested person. Subsection 5, along the route of the proposed way leave calculated to bring the application clearly and in a comprehensible manner to the notice of all persons using land over which the proposed way leave is likely to be created. Okay, I don't understand, but let's just move on. Application for communal right of way. Now we say communal right of way is where people pass. Just people, you and me, ordinary folks. Section 145. A county government, an association, or any group of persons may make an application to the Commission for communal right of way. Determination on creation of public right of way. So, Section 146. The Commission shall, on receipt of all information prescribed under this Act, after at least 90 days from the date of the serving of notices under this Act, consider all the information so received and all representations and objections made by any person served with a notice under the aforesaid subsections, and recommend to the Cabinet Secretary whether to appoint a public inquiry to give further consideration to the representations, refer the application to the county government for its opinion on whether to approve the application, or initiate and facilitate negotiations between those persons who have made representations on the application and the applicant with a view to reaching a consensus. So in this is the public right of way. It's just deeper into it, okay? So it just goes deeper into the whole idea, into the whole whatever process. If the commission has proposed the creation of a public right of way of its own motion, and representations have been made on that proposal, okay. The commission shall recommend to the cabinet secretary only that the cabinet secretary exercise the powers under subparagraphs 1, 2, or subsection 1. The Cabinet Secretary shall determine whether or not to create a public right of way after taking account, as the case may be, of the recommendations, the advice of the county government, the outcome of any negotiations created under this section. Gosh, this section just goes on and on. So the Cabinet Secretary will create, by order in the Gazette, a public right of way under this section with conditions, okay? If an agreement has been reached between the parties to any negotiations, okay, the Cabinet Secretary intends to create a public right of way but not to accept any amendment. Okay, this is just too much information, which is just not doing it for me right now. So subsection 6, the order of the Cabinet Secretary to create a public right of way shall delineate the route of that public right of way, be published in Gazette, be notified to a county government having jurisdiction along the route of the public right of way, okay, be publicized in any manner which is calculated to bring it to the attention of people, come into force 30 days after it has been published in the Gazette. Any person who makes any representation or objection to an application within 6 weeks after the order has been made may appeal to the court on a point of law only against an order made by the Cabinet Secretary, okay? Okay, so there's no judicial review also allowed. Now, power of registrar with respect to public right of way. Where's my water? I'm so thirsty. So public, where am I? Compensation for the power of registrar with respect to public right of way. Now, under section 147 of this act, if the cabinet secretary has made an order to create a public right of way, the commission shall cause all the necessary documents, plans, demarcations, and surveys compensation in respect of public right of way, subject to the provisions of the section of the route of that public right of way, to be delivered to the registrar to enable the registrar to exercise the powers. On receipt of the information referred to, the registrar, after the expiry of the time allowed to appeal against the order of the cabinet secretary, take any necessary, desirable, or prescribed action which the registrar may consider necessary and desirable, or which may be prescribed, to cause to be recorded. So the registrar will record in such forms the njia or the right of the public right of way on any certificate of occupancy or document of title, okay, It will cause to be delivered to the registrar all certificates of occupancy having reference to land over which the public right of way has been created, held by the person occupying such land, by any lender of money in the case of a chargee. Okay, so this is to amend the certificate to include the public right of way so that in future people are not misled. Okay, compensation in respect of public right of way. Now, Section 148. Compensation shall be payable to any person for the use of land of which the person is in lawful or actual occupation as a communal right of way, and with respect to a way in addition to any compensation for the use of land for any damage suffered in respect of trees, crops, and buildings. So, compensation will be given to the people whose land has been used to for the access to public right of way. Okay, also the compensation relating to a way leave or communal right of way shall not be paid to a public body unless there is a demonstrable interference of the use of the land by that public body. Okay, the subsection 3, damage caused as a result of the creation of a way leave shall include any preliminary work undertaken in connection with surveying or determining the route of that leave. So the damage caused on inspection, on surveying of the or on constructing that the barabara or the road, that damage is also going to be uh, to attract compensation. Now, the duty to pay compensation under this section shall lie with the state department, county government, or public authority in case of a way leave. Okay. If the person entitled to compensation under this section and the body under a duty to pay the compensation are unable to agree on the amount or method, uh, or if the person entitled to compensation is dissatisfied with the time, with the delay, mhm, the person may apply to the court. So this section allows for the person to apply to the court in case of delays of compensation, in case of the amount that was negotiated is not satisfied. They will apply to the court to determine amount and method of payment. So, Section 6, the Commission shall make regulations prescribing the criteria to be applied in the payment of compensation under this section and to give effect to this section. Okay. Okay, let's move on. Section 149, power of courts to enforce public rights of way. In determining any question or dispute concerning the existence or effect of a public right of way, a court may make an order on any condition which it thinks fit on all or any of the following matters. Number one, the existence of a public right of way. So, in determining any question or dispute concerning existence or effect of a public right of way, a court can make an order on any condition which it thinks fit. So, on all or any of the following matters. So, the existence of a public right of way can have conditions: the enforceability of a public right of way against a person, the extent or of the use of the easement, analogous right or public right of way, and whether that use exceeds the permitted use under the terms, the question whether any work is required to be done under the terms of an easement or a public right of way, the reasonable and proper cost of any such work as is required to be undertaken. Okay, the date, the person or persons by whom the cost of any such work is to be borne. Okay, the date by which and the manner in which any such work is to be undertaken. Okay, the entry on any land, whether or not it is land over which an easement or a public right of way has been created for the purpose of doing the work, any other matters arising. Yes, we finished. Now we are going to the final part 11 on miscellaneous. I don't know what this is, but let's just go through it quickly. There are only about 10 sections remaining before we conclude the act. So, jurisdiction of Environment and Land Court. Section 150. The Environment and Land Court established in the Environment and Land Court Act is vested with exclusive jurisdiction to hear and determine disputes, actions, and proceedings concerning land under this Act. We already said that the jurisdiction to hear disputes on matters relating to land and environment fall in the Environment and Land Court. Substituted service. If the Commission, under Section 151, if the Commission is satisfied that a notice effected and cannot be served personally or by post, either because the person is evading service or for some other reason, the Commission may order service to be effected by affixing a copy of the notice in a conspicuous place. So they will affix the copy of the notice in a conspicuous place, okay? On or as near as may be to the land where possible. If the land is community land, at the offices of the community land committee or other public place. If the land is public land, at the offices of the county government, publishing a copy in the gazette, and one or more newspapers circulating. Okay, this is self-explanatory repetition from what we said. Rights of entry under section 152. Just a minute, I'm coming. Okay, so we are almost done. So, rights of entry under section 152, any person authorized in that behalf by the commission shall have power on giving of not less than 48 hours notice to enter and inspect at all reasonable times between the hours of 6 a.m. to 6 p.m. any public land other than land occupied exclusively as a dwelling house for any purposes. Okay. Now, the notice required by subsection 1 to be given prior to any entry onto land shall specify clearly the purpose for which and at time which the authorized person will enter the land. Every person authorized to enter or inspect land under this section shall be furnished with a written authorization signed by the Commission. If any person authorized under the section causes any damage, the Commission will pay. Okay. Land Compensation Fund, Section 153. There shall be established a land compensation fund to be known as the fund. The objects and purposes of the fund is to provide compensation to any person who, as a result of the implementation of any of the provisions by national government, county government, urban area, or city, suffers any loss or deprivation or diminution of any rights in land. Uh, So, this land compensation is to pay damages to people who suffer land that is as a result of any public body. The fund shall be administered in accordance with the provision relating to public funds. We know that. So fees, section 154. The cabinet secretary shall prescribe the rates of fees for all matters in respect of which prescribed fees are required to be paid by any person and shall keep such fees under continuous review. Fees under this section shall be at a per centum rate of the value of the land, the subject of the application or other matter in respect of which fees are required to be paid. The registrar shall refuse to make any entry on the register or register any document in respect of any grant of land or any disposition of or arising in connection with a land in respect of which a fee has not been paid in whole or in part, unless the registrar is satisfied on the basis of written evidence that the fee has been waived. So when you are registering land under this act, you pay a fee. If you want to amend the register, you pay a fee. If you want to put caution, you pay a fee. All these things. Unpaid fees or expenses incurred by the government in connection with any attempt to recover those unpaid fees shall constitute civil debt. Okay. Unlawful occupation of land. Section 151 says any person who, without express or implied lawful authority or without any right or license under customary or statutory land law to do so, occupies or erects any building on any public land, clears, digs, plows, or cultivates or grazes animals over any public land, cuts, removes timber or other produce on any public land shall be taken to be in unlawful occupation. Mm, if if with respect to public land the commission is of opinion that someone is in lawful occupation, will serve on that person a notice, or give to that person an oral communication, mm, requiring them to vacate that land within any time and subject to any conditions, as to removal of buildings, reaping of growing crops, and any other matters which the justice of the case may require. Any notice referred to shall inform the person that it has a right to be heard. He has a right to be heard in connection with showing cause as to why the person should not vacate from the land, in determining whether to serve a notice or oral communication, and the period of time to be specified in the notice by the end of which the person is required to vacate the land, the Commission shall take account of whether the person has reasonable belief that the person is in lawful occupation of land. So, in determining whether to serve a notice, the Commission will consider whether the person has reasonable belief that he is lawfully occupying that land, whether the use, including crops, are ready to be harvested, the length of time that person has been on that land, and the person's age and general circumstance, whether that person is living with any dependents, whether that person or dependents are in employment near to that land, whether the occupation of the land took place peaceably or by force, whether the occupation of the land is preventing some necessary development, whether the nature and environment of the land and where the land is land reserved for primary use of wildlife, whether occupation will interfere with wildlife, whether in all circumstances it will be reasonable to pay any money to the person who should vacate from the land, any other factors, okay, which seem relevant include any matters that the person occupying the land brings to the attention of the Commission. A person served with a notice or oral communication under this section shall, within not more than 60 days, show cause to the Commission as to why the person should not vacate the land to which the notice relates. So the person served with this notice or oral communication will not more than 60 days show cause to the commission. So he has 60 days to show why he should not vacate. If a person does not show why he should not vacate within 60 days, they have no reasonable excuse for not vacating. Where if after considering any representations made by the person attempting to show cause, the commission determines that the person has failed, the commission shall inform the person to vacate. Okay. And a person who responded to the notice to show cause but who failed to do in terms of subsection 5 may apply to the court for relief against the operation of that notice or oral communication within 30 days. So you can apply to the court. An application for relief is not to be taken as an admission by the person applying for relief that the person is in unlawful occupation, that the commission has the right to require the person to vacate. All notices and oral communications which were required to be served by the commission were properly served. The period by which the land must be vacated specified in the notice was reasonable or had expired. The court may, after considering the matters, grant relief to the person applying for the same on any terms. Without prejudice, the court may cancel the notice or oral communication to vacate, postpone the operation to vacate, vary the operation to vacate, vary any terms to vacate, vary the amount of any payment to be paid. Okay. Now, if the court has confirmed the notice or oral communication with or without any alterations, the notice or oral communication, the person on which has been served shall be adjured to comply with that notice as confirmed by the court. Obstruction of public land rights of way. Section 156. If the Commission is satisfied that there has been any wrongful obstruction or encroachment on any public right of way, it may make an order requiring the person responsible for that obstruction to remove that obstruction. Any notice made by the Commission under subsection shall be served on or communicated to the person who is accused of obstructing. Okay, a person served with a notice may request the Commission to reconsider the notice within the time by giving reasons. A person who does not take action under subsection 3 shall be taken to have accepted the notice and shall be under a duty to comply. If the Commission has reconsidered the notice in response to a request and determines to confirm, it shall inform the person who made the request for reconsideration. A person whose request for reconsideration of the notice has resulted in the notice being confirmed may appeal to a court against that confirmed. Now, subsection 7, a court hearing an appeal under this section may confirm the notice and order the person to desist from obstructing or encroaching on the public right of way, or suspend the operation of the notice, quash the notice. Offenses under section 157, any person who knowingly makes any false statement, orally in writing, in connection with any disposition or transaction affecting land, knowingly gives any false information in writing or orally in connection for any call of information, okay, fraudulently procures the registration or issue of any certificate of title or any document related to land, the making of an entry or endorsement of any matter on any document relating to land, or the cancellation or amendment of any document related to land, fraudulently alters, adds to, erases, defaces, mutilates, or destroys any document of title relating to land, okay? So any fraud, any malpractice, any forgery, any distraction will be liable to a fine not exceeding 10 million shillings or imprisonment not exceeding 10 years. Okay. Any person who unlawfully occupies public land commits an offence and is liable to a fine not exceeding 500,000 shillings, and in the case of a continuing offence, to an additional fine not exceeding 10,000 shillings. Okay. Mm-hmm. Any person who wrongfully obstructs on a public right of way who does not within the time specified in any notice served on the person under section 112 against the notice within the time specified. This is just bull. So subsection 4, any person who willfully delays, obstructs, hinders, intimidates, or assaults any person authorized under this act to inspect land, this is like the compulsory acquisition, commits an offence and is able to pay 500,000 shillings. Any person who, being an authorized officer under this act with a general or specified function, in the course of his function unlawfully or with force enters on the land of any person, commits any damage to the land or anything on the land, whether naturally on the land or stock owned or crops, is liable to a fine not exceeding 500,000 shillings. If a court has convicted any person of an offence under this section and the commission of that offence enabled that person to obtain or retain or regain any interest in land would otherwise not have been able to obtain, the court may punish them and in addition may make such person, okay, may make such person stop from profiting from that gain. Okay, it will also direct the commission to commence proceedings to revoke the allocation or terminate a lease, direct the registrar to cancel any entry in any register, require the person to make a restitution to any person who suffered loss. The registrar shall not be personally liable in respect of this act. Okay. So corrupt transactions, section 158, nothing shall be taken to validate, affirm any legal effect to any grant of public land, any issue of a certificate of ownership of land, or any disposition or any contract for that is obtained by corruption. Notwithstanding this, a transaction shall be illegal from its inception, shall be void and no effect. For purposes of this section, a transaction shall be considered to be effected or tainted by corruption when either any party to or involved directly or indirectly in the transaction in respect of which it is alleged that an action was corrupt is convicted of corruption, and all final appeals arising have been concluded. Any employee of the Commission, public official, retired or is retired in public interest from the position on the grounds that the person has been engaged in corrupt actions, a court of competent jurisdiction so determines. So any person occupying land obtained as a consequence of participating in any transactions of corruption shall be liable to forfeit that land to the government without any compensation. Notwithstanding, a transaction covered by this is void. A person occupying land as a consequence will also be obliged to comply with all terms and conditions. Okay. Now, land sizes. I'm sorry I'm going fast because we are finishing and I don't want us to waste any more time. Land sizes under Section 159. Within 1 year of the coming into force, the Cabinet shall commission a scientific study to determine the economic viability of minimum and maximum acreages in respect of private land for various land zones in country. The findings of the study shall be available for the public to make observations. Within 3 months after the publication of the final report of the scientific study, the Cabinet shall table the report to Parliament for debate. The Cabinet shall also prescribe rules and regulations for determining minimum and maximum acreages in private land. The registrar shall not accept for registration any instrument that confers interest in land that has the effect of breaching the maximum or minimum acreages in respect of public land. General power to make regulations, section 160. The commission or the cabinet secretary will make regulations under this act. Okay. Such regulations may prescribe the forms to be used, the management of the land compensation fund, the use and management of public rights of way, the procedures to be followed with respect to any claim for compensation, the manner of assessing value of an interest in land, the minimum and maximum land holding acreages. Okay. Subsection 2. Without prejudice, the Commission shall have the powers to make regulations to secure the land rights of the minority communities to individually or collectively access and use land and land-based resources following an inventory, to prevent and manage land-based disasters, to establish, plan and manage refugee camps, to deal with issues that arise from internal displacement with respect to squatters, to establish mechanisms for their removal, to facilitate and their settlement, to facilitate negotiation between private owners and squatters, to transfer utilized land and land belonging to landowners to squatters, absentee landowners to squatters, to facilitate the regularization of existing squatter settlements formed on public and community land. Repeals. Section 161. The written laws set out in the schedule to this act are hereby repealed. All other law relating to land shall be construed with the alterations, qualifications, exemptions necessary. Now, savings and transitional provisions with respect to rights, actions, dispositions. Section 162, unless the contrary is specifically provided in this act, any right, interest, title, power, or obligation acquired, accrued, established, coming into force, or exercisable before the commencement of this act shall continue to be governed by the law applicable to it immediately prior to the commencement of this act. So all those rights that have been created before this act came into force will continue to apply the previous acts, okay? Unless the contrary is specifically provided in this act or the circumstances are such that the contrary must be presumed, if any step has been taken to create, acquire, assign, transfer, or otherwise execute a disposition, any such transaction shall be continued in accordance with the law applicable to it immediately prior to the commencement of this Act. So immediately prior to the commencement of this act, mhm, immediately prior to the commencement of this act, uh, so it's the same. So it will apply to the law. Immediately before this, the law that is was in application then will apply. Any instrument executed before the commencement of this act whereby any disposition permitted is completed may be presented for registration in the prescribed register, and the question whether any instrument is to be registered shall be determined by the registrar by reference to the law in force at the time of its execution. Subject to the provisions of paragraph A, the provisions of this act shall apply to that instrument if it had been executed after the commencement of this act. Now, if a lessor or lender had initiated any step to forfeit a lease or to foreclose a charge, as the case may be, before the commencement of this act, a court may, on the application of the lessee or charger, issue an injunction to the lessor to stop the continuation of any such step. So, if a court had issued an injunction under subsection 4, the lessor or lender to whom the injunction has been issued may commence any action under this act to terminate that lease or that charge to an end. Okay. So, amendment of Cap 318, the Section 160 of the Agriculture Act, Cap 18, 318 is amended by deleting paragraph D, deleting this. We are done. Repealed laws is the Way Leaves Act and the Land Acquisition Act. So, congrats, we made it. We are done with the Land Act of Kenya. Yes, bye bye. See you next time in my Read with Me series. Bye.